ಕೋರ್ಟ್ ಆಫ್ ಸರ್
ಹೇಳಿ ಸರ್.
ಸಿಟ್ಟಿಂಗ್ ಎಷ್ಟೊತ್ತಿಗೆ?
ಗೊತ್ತಿಲ್ಲ ಸರ್, ಅಲ್ಲೇ ಅನೌನ್ಸ್ ಮಾಡೋದು.
ಬೇರೆ ಒನ್ ಅವರ್ ಆಗ್ಬೋದಾ? ಲೇಟ್ ಎಲ್ಲಿ ಇಲ್ಲಿದಾರ ರಾಜ್ಭವನ್?
ಇಲ್ಲ ಸರ್.
ಹೌದಾ?
Hello.
ಎಷ್ಟು ಹೇಳ್ತೀವಿ ಅಲ್ಲೇ ಇದೆ ಅಂತ ನೆನ್ನೆನೂ ಹೇಳ್ದೆ. ಇರ್ಲಿ ಬಿಡು, ನಂಗೆ ಅಲ್ಲಿರೋದ್ ಗೊತ್ತಿಲ್ಲ, ತಗತೀನಿ ಬೇಕಾಗಿರುತ್ತೆ ಎಂದೆ ನಾನು.
ಹಲೋ ಸರ್, ಕೇಳಿಸ್ತಾ ಇದೆಯಾ ಸರ್? ಹಲೋ.
ಹಾ, ಕೇಳಿಸ್ತಾ ಇದೆ, ಕೇಳಿಸ್ತಾ ಇದೆ.
ಹಾ, ಓಕೆ ಸರ್. ಸರ್, ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ನಾನ್ ಕಾಂಪ್ಲೆನ್ಸ್ 3 ಟೈಮ್ 4 ಟೈಮ್ ಇದೆ. ಹಲೋ ಹಲೋ ಸರ್.
Cross appeal number will one this. Objection. Cross appeal number.
ಮಾಡಿದ್ರೆ ನನ್ ಮುಖ ಇದು ಬರ್ತಿಲ್ಲ. ನನ್ ಮುಖ ಅವ್ರಿಗೆ ಕಾಣುತ್ತೆ.
Tomorrow. We'll verify tomorrow. Monday. Monday and Tuesday we are fixed for CPC. Let us see tomorrow.
Be granted, my lord, for extension, my lord.
So normally,
Yes,
time is fixed. The court itself will
ಆಗಿದೆ.
send in a letter to the High Court for extension.
ಎಲ್ಲ ಆಗಿದೆ ಕೇಳಿ ಅಂತ ಹೇಳಿದ್ರು, ಇಲ್ಲಾಂದ್ರೆ ನಾವು ಮಾಡ್ತೀವಿ ಅಂತ ಹೇಳಿ ಲೇಟ್ ಆಗ್ತದೆ ಅಂತ.
It is a further.
15 days time. Even other side council has also no objection, my lord.
No, it is because it is not
Yes,
the
my lord,
fault of the.
it is the court has to
Yes, they
write
have
a
to
letter,
send a
my lord, to
letter.
the register, my lord.
Yes.
ಲೇಟ್ ಆಗ್ತದೆ ಅಂತ ಹೇಳಿ ಅದಕ್ಕೋಸ್ಕರ ಎಲ್ಲ ಗೊತ್ತಿರೋದ್ರಲ್ಲಿ ಒಂದು 15 days ಟೈಮ್ ಗ್ರಾಂಟ್ ಮಾಡಿ ಅಂತ ಹೇಳಿ.
Why, madam?
Matter dispose ಆಗಿದೆ. ಬರೀ ಒಂದು matter dispose ಆಗಿದೆ, ಇನ್ನೇನು dispose ಆಗಿದೆ.
Yes, my lord.
You have to.
Previous one more council has been represented, but
Why, madam? Yes. ಯಾರು ತಂದಿದ್ರು
List number 3, page number 1, serial number 1 and 2. List number 3, page number 2, serial number 3 to 8. List number 3, page number 3, serial number 9 to 12. List number 3, page number 4, serial number 13 to 17. List number 3, page number 5, serial number 18 to 20. Page number 6, serial number 21 to 25.
My lord, serial number 25, my lord, there is some complication. I have to discuss with the legal expert. That is why 1 week time may kindly be granted. Whether my IA survives or not is the question. That is why I will discuss. I will make the submission next week, my lord. Next week at any rate.
Leave this matter next week.
Page number 3, page number 7, serial number 26 to 30. Page number 8, serial number 31 to 35. Page number 9, serial number 36 to 38. Page number 10, serial number 39 to 47.
40, my lord, serial number 40.
Yes.
Next week, my lord, next Wednesday it can be taken up.
The request of council for the appellant. Use this matter next week.
Any date can be given.
Bharat next week. Appellant. Respondent. Take my yes.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಂತಂದ್ರೆ ಫ್ರೈಡೆ ಅಥವಾ ವೆಡ್ನೆಸ್ಡೇ
Friday.
ಬರಕ್ಕ 3 ದಿನದಲ್ಲಿ ಯಾವ ತರ ಬಂದಿದೆ
Friday.
Page number 11, serial number 48 to 50. Page number 12, serial number 51 to 57.
50? Yes. The request of council for the appellant. Use this matter.
Page number 30, serial number 58 to 63.
58. Waiting PCR. Yes.
Page number 14, serial number 64 and 65. Page number 1, hearing interlocutory application matter, serial number 1 to 53. List number 2, for orders regarding non-compliance of office objection, third time matter, serial number 1 to 4.
The officer like
Office objection, third time matter, serial number 1 to 4.
3 weeks.
Fourth time matter, serial number 5 to 8.
3 weeks.
Fifth time, serial number 9 to
3 weeks. 3 weeks.
sixth time, serial number 16 to 18.
2 weeks. Finally.
Seventh time, serial number 19.
2 weeks.
Eighth time, serial number 20.
2 weeks finally.
Serial number 20, I have complained, my lords. I will verify, my lords.
Yes, it's very good. Yes.
I have already completed.
Yes.
Number 3 for dismissal, Y. Prasad for appellant. Number 3 for dismissal, serial number 1, Y. Prasad.
The matter was posted on 11/20/23. Matter is called, none appear for the appellant. As a last chance, matter was been ordered to be posted on 21/11/2023. And matter is posted on 21/11/2023. Appear for the appellant. Directed to release this matter on 22/11/2023. 11/20/23, when the matter is called, none appear for. Directed to be posted today. The caption for dismissal. Is called, none appear for the appellant. Yes, opponent. It is dismissed for non-posted.
Serial number 2, Ashok and Martin for appellant. Prakash HC.
For dispensation of notice to R3. R3 is dispensed at the risk of the appellant. IA 1 of 2023 is not plus. Are filed for same purpose. Now the IA number 2 now. IA number 2 of 2023 ಎರಡು ಬರ್ದಿ ಹಾಕಿದಿಲ್ಲ. ಅಲ್ಲ IA number 2 ನ ಎರಡು ಹಾಕಿದಿರ 2 of 23 2 of 23. IA 1 of 23 not pressed by the advocate appellant. Since IA number 2 of 23 are filed for same purpose and IA number 2 of 23 is allowed. Yes. Yes. Notice not ordered on impleading R6 to R7. Yen impleads. Yen ಯಾವ್ದು IA ಅದು impleading? ಅದರಲ್ಲೇ ನೋಟಿಸ್ ನಾಟ್ ಆರ್ಡರ್ಡ್ ಅಂತಿದೆ, ನೋಟಿಸ್ ಆಗಿಲ್ವಾ? IA 1 of 20. ನೋಟಿಸ್ ಆಗಿಲ್ಲ. IA 1 of 2023 or owner insurance not the party as the respondent to add 6 and 7 first statement. Accordingly, IA is allowed order directed in the first statement. Article amendment ಮಾಡೋದಕ್ಕೆ ಡೈರೆಕ್ಷನ್ ಮಾಡಿದ್ದಾರೆ. ಅಲ್ಲ IA ಒಳಗಡೆ 6-7 ಇಲ್ವಾ? Council for the appellant has filed an IA 2 of 2023 stating that oversight respondent number 6 and 7 who are that owner and insurer of the vehicle were not included as a party as a respondent. Try to add 6 and 7 ಅದರಲ್ಲಿ IA 6 and 7 ಅಂತ ಕೇಳಿದ್ದೀರಾ. IA is allowed. Now you have now that notice has to go to 6 and 7. Yes, issue notice. Respondent number 6 and 7. ಯಾರಿದ್ದಾರೆ? ಇದು ಹೋಗ್ಲಿ, ಹೊಸದಾಗಿ ನೀವು ಇಂಪ್ಲೀಟ್ ಮಾಡ್ತಾ ಇದ್ದೀರಲ್ಲ, ಲೆಟ್ ದೆಮ್ ಗೋ ಫಸ್ಟ್ ಒನ್ ಟೈಮ್ ನೋಟಿಸ್, then we'll see. Yes.
Number 3, O Maheshwar appellant, Nagaraja Hegde. Number 3, O Maheshwar appellant.
Memo for dispensation of notice to R2 filed by the appellant is allowed. Notice to R2 is dispensed at the risk of the appellant.
Number 4, B. Pradeep for appellant, Pradeep Casey.
Each side is granted to do the needful.
Serial number 5, Manjunath Reddy for appellant, C. Shankar Reddy.
I appeal for second respondent. If the
Huh?
claim petition is dismissed,
Dismissed. Yes.
how soon?
Alternate counsel for the appellant. ಮತ್ತೆ ಇದನ್ನ ಯಾಕೆ dispensation ಮಾಡ್ತೀರಾ?
Notice only.
Yes. Alternate counsel for the appellant submits that memo. He will not press memo. He will withdraw that memo for dispensation of notice to R1. The memo filed by that appellant is dismissed as withdrawn. Notice to respondent number 1. Yes. You pay the process.
Number 3, Manjunath Reddy for appellant, United India.
United India ಯಾರಿದ್ದಾರೆ? You are there, ready. R2 is served unrepresented. Alternate Reddy is directed to take notice for R2. Alternate counsel for the appellant is directed to serve one set of copies. Counsel for the appellant has filed a memo seeking dispensation of notice. R1, R3, memo was taken on record. What about R4? Sriram Insurance. Yarida Sriram. R1 and R3 is dispensed at the risk of the appellant. R4 ಯಾರಿದ್ದಾರೆ? Sriram ಇವರು ಇದ್ದಾರೆ. Yes. Respondent number 4, B. Pradeep is directed to take notice. Yes.
Number 7, Vijay Prasad Reddy for appellant, B. Pradeep.
For respondent.
Yes. Ready.
Ready, my lords. Case of injury.
Counsel for the appellant has filed a memo. Session of notice to R2. What is dispense at the. Yes.
Date of action 17/5/2019.
27. Which is that MEC, Mr. Yes. 27, huh? Yes. That 7 days in hospital, huh?
7 days in hospital. 9 days, my lords. Sorry, 9 days.
Come on, ಎಷ್ಟು ಅಸೋಸ್ ಮಾಡಿದ್ದಾರೆ?
12,000.
Yes. ಯಾವ ವರ್ಷ? 2019. Disability?
Disability.
ಕಂಡಿದ್ದಾರಾ? What is that other head? Also future expenses towards amenities. Loss of income during the later period ಕೊಟ್ಟಿಲ್ಲ. Just
Plus 6%.
yes, that's all. Today, Prasad, Senate Council appearing for. Second has contended that at the time of the accident, Second was working as a real estate agent, I think 30,000 per month. Notional income of the claimant as 12,000 per month is on lawyer side. Due to that accident, Claimant has suffered serious injury. The patient for a period of 9 days. He has suffered a lot of pain during the treatment. He has suffered this disability. Happiness throughout his life. Compensation awarded by the tribunal. He has suffering loss of immunities, incidental expenses and lawyers. And has failed to grant any compensation for income during the later period. Hence he sought for management of compensation. For contra, E. Pradeep, Learned Council appearing for insurance company has contended that even though claimant has claimed that he was earning 36,000 per month. He has not produced any document to establish the same. Therefore, tribunal has rightly assessed notional income of the claimant as 12,000 per month. Secondly, he has contended that injuries suffered by the claimants are minor in nature, but inpatient only for a period of 9 days. 7 days. 7 days. Considering that injury suffered by the claimant and considering that evidence of the doctor, compensation awarded by the tribunal for pain and suffering, loss of immunities, other incidental expenses is just and reasonable. Hence, he sought for dismissal of the appeal. Heard the learned counsel for the parties. Rose, judgment and award. It's not in dispute. Claimant has suffered an injury. The road traffic accident occurred on 17/5/2019 due to rash and negligent driving of driver of car bearing registration number 804 MP 5279. Even though claimant has claimed that he was earning 30,000 per month, he has not produced any document to establish the same. Under the circumstances, notional income has to be assessed as per the guidelines issued by Karnataka Legal Service Authority. For the accident occurred in 2019, notional income has to be considered as 14,000. Tribunal has rightly assessed whole body disability is 15%. At the time of the accident, claimant was aged about 62 years. Multiplier applicable to the age group, which is partly loss of future earning has been reassessed as follows.
14,000, 15%, 1,400.
Due to the accident, claimant has suffered the aforesaid injury. Was inpatient for a period of 7 days. He has suffered a lot of pain during the treatment. He has suffered this disability and unearthiness throughout his life. During the evidence of doctor and injuries suffered by the claimant, client enhanced the compensation for is 20,000 to 40,000. Claimant is also entitled for loss of income during the later period for 3 months. Accordingly, the compensation awarded by the tribunal in the other hand are just and reasonable. The appeal is allowed in court.
Number 8, and the secretary for appoint W. Ramakrishna.
ಇದರ ಪಾಸ್ ಔಟ್ ಮಾಡ್ಬೇಕಾ ನೆಕ್ಸ್ಟ್ ವೀಕ್ notice to R1 is dispensed from the risk of the appellant. Please this matter next week.
Girimalaya for appoint B.C. Chivanegowda.
Necessary part that is granted to the needful.
For appoint H.S. Sundaraju.
Yes. R1 is dispensed from the risk of the appellant. Ready? ಯಾಕೆ ಮತ್ತೆ ಲೋಕ ಅದಾಲತ್ ಆಗ್ಲಿಲ್ಲ? You not signed, you are not agreed. Huh? Yes. It is matter next week and there is request of the court.
Number 11, Antarashtriya for appoint B.C. Chivanegowda.
Ready? Ready? Notice to R1 is dispensed at the risk of the appellant. Yes. 115. Yes. Discussion ಎಲ್ಲಿದೆ? Paragraph. ಕ್ರಿಮಿನಲ್ ಎಲ್ಲಿ ಡಿಸ್ಕಸ್ ಮಾಡಿದಾರ? ಈ ಸಮಯ yes.
It's also not include. The confidence in the class examination in the table. Respondents is it must. Class examination 6 6. I'm not prepared any detail with regard to that. The deputy certificate starting out and for the late. Similarly to the particular in 3 times a year than the permanent disability. The below disability in the case of arbitration, but in the present case, insurance not that can be modulated.
The percentage of reserve the range of the million.
Yes. Medical expenses of 51,017 medical basic in the state.
ಅಮೆರಿಕಲ್ ಬಿಲ್ ಎಷ್ಟಿದೆ?
51,017.
ಅಲ್ಲಿಗೆ 8,000 ಇದು ಕೊಟ್ಟಿದ್ದಾರೆ.
Future medical expenses.
ಸ್ಪೈನ್ ಅಂಡ್ ಅಗನಿ ಕೊಟ್ಟಿದ್ದಾರೆ. ಎಲ್ಲಿದೆ ಎವಿಡೆನ್ಸ್ ಡಾಕ್ಟರ್ ಫ್ಯೂಚರ್ ಮೆಡಿಕಲ್ ಎಕ್ಸ್ಪರ್ಟ್?
I think of in my
There is that insertion of implant. Where you read? ಅದು ಯಾವ
affidavit evidence ಅಲ್ಲಿ
fracture of left tibia. Recently examined the patient for disability following observation.
Following observation, following the fracture of left tibia, effective one to fracture of left tibia with implants.
Come back.
Shantraj Learned Council appearing for. The climate has contended that. Due to the extent, it has suffered serious injury. After has been examined, his position, he has deposed that the climate has suffered 18% disability to whole body. Others deposed that there is a shortening of left leg of the petitioner. Also, in his class examination, he has admitted that climate has suffered disability to the tune of 50%. Therefore, whole body disability is assessed by the tribunal is on lawyer side. Contended that at the time of the accident, climate was earning 15,000 per month. Tribunal has assessed notional income of the climate as 6,000 per month is on lawyer side. Thirdly, he has contended that due to that accident, climate has suffered grievous injury. Yes, in hospital, he was inpatient for a period of 7 days. He suffered a lot of pain during the treatment. He has suffered with disability and unhappiness throughout his life. The compensation awarded by the tribunal, pain and suffering, other incidental expenses is on lawyer side. Tribunal has failed to grant any compensation for loss of amenities. Hence, he sought for enhancement of compensation. Kanta, Shivanagowda Learned Council appearing for insurance company has contended that the claimant has examined the doctor. Doctor has deposed that the claimant has suffered whole body disabilities is 18%. With respect of limb disabilities, he has assessed at the tune of 50%. Therefore, the whole body disability is assessed by the tribunal is just and reasonable. With respect of income is concerned, he has contended that even though claimant has claimed that he was earning 15,000 per month, he has not produced any document to establish the same. Therefore, tribunal has rightly assessed notional income of the claimant as 6,000 per month. Lastly, he has contended that considering that injury suffered by the claimant and considering that age and avocation of the claimant, the overall compensation awarded by the tribunal is just and reasonable. Lastly, he has contended that due to the accident, claimant has suffered grievous injury. He has undergone surgery. He requires future medical expenses for removing of the implant. Tribunal has not granted any compensation for future medical expenses. Hence, he sought for dismissal of appeal and review. Heard the Learned Council for the parties. Rose, judgment and award. It is not in dispute. The claimant has The claimant has suffered an injury in a road traffic accident occurred on 18/10/2015 due to rash and negligent driving of driver of bus bearing registration number AA51 A6409. Due to the accident, claimant has suffered the following injury. Dr. Venkatram Kumar has been examined as PW2. In his evidence, he has deposed that the claimant has suffered 18% disability to whole body. In his past examination, he has deposed that there is a shortening of left lower limb. The disability to the particular limb is 3 times higher than the permanent disability. And he has also assessed that permanent disability suffered by the claimant is 50%. Considering that permanent disability suffered by the claimant and considering that evidence of the doctor, the tribunal has rightly assessed whole body disabilities 18%. Even though claimant has claimed that he was earning 15,000 per month, he has not produced any document to establish the same. Therefore, notional income has to be assessed as per the guidelines. For the accident occurred in 2015, notional income has to be considered as 9,000. At the time of the accident, he was aged about 24 years. The multiplier applicable to the age group is 16. Accordingly, loss of future earning has been reassessed as follows. 18%. Due to the accident, the claimant has suffered the aforesaid injury. He was inpatient for a period of 7 days. He has suffered a lot of pain during the treatment. He has suffered with disability and unhappiness throughout his life. The compensation awarded by the tribunal, pain and suffering, has to be enhanced to. I incline to enhance the compensation for pain and suffering from 40,000 to 50,000. The claimant is also entitled for loss of immunities, 40,000 rupees. Loss of income during the later period, as granted by the tribunal, 6 months. Loss of income during the later period has to be granted for 6 months, even in the income of that. In respect of future medical expenses, the evidence of the doctor has deposed that the claimant has undergone surgery and there is an implant and he has not assessed for the cost of removal of implants and the future surgery. Considering that injury suffered by the claimant and considering that evidence of the doctor, I am of the opinion that future medical expenses can be awarded 20,000. In respect of other head, compensation awarded by the tribunal is just 20. 8 ಕೊಟ್ಟಿದ್ದಾರಲ್ಲ. In respect of medical expenses, attendance charges, food and nourishment has to be enhanced from 60,000 to 72,000. Compensation awarded by the tribunal in the other hand are just and reasonable. ಶಿಕ್ಷೆ ಕೊಟ್ಟಿರೋದಲ್ಲ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಸೇಮ್ ವಿಲ್ ಕ್ಯಾರಿ. Ready? Who is that Mallikarjun? No, Suresh, that climate insurance company appeal.
Serial number 12.
Yes, Mr. Suresh.
Serial number 12, my lord. I appear for the appellant.
Notice has to be served to whom?
Take steps by paper publication. Respondent number 2, third time ತಗೊಂಡಿದ್ದೀವಿ ಸ್ವಾಮಿ. Tribunal ಮುಂದೆ he has been mentioned as R1 absent ಅಂತ ಮಾಡಿದ್ದಾರೆ. Ex parte ಆಗಿಲ್ಲ. I will take some this paper publication from.
Yes, learned counsel for the appellant place 2 weeks times to take necessary steps in respect of all. Want to seek releasing of the amount, IA. Yes, what is that, Mr. Suresh? His application for releasing that amount.
Yes, my lord.
What ground you are challenging?
It is challenged on the ground of liability also, my lord.
What is that liability?
I will just submit, my lord. I have taken the second ground, my lord. The tribunal erred in not coming to the conclusion that the accident was due to sole negligence on the part of the respondent number 1 in crossing the road, as he has crossed the road at a place where he ought not to have crossed the road.
I know.
Next,
Even if you succeed,
second round I have taken my lord. That respondent number 1 has intentionally not produced the spot sketch, as the accident has occurred in the middle of the road, which
you are saying that he is also contributed to that accident.
no, my
That
lord.
maybe
My one submission, my lord. In the middle of the road, that accident has taken place. Therefore, he is sole negligence. I have taken up that contention, my lord. That has to be decided.
yes, where is that finding of the tribunal?
Yes, my lord. I will take you. I will read it. Issue number 1, my lord.
Yes.
Para 11.
Yes.
It is the case of the petitioner that on 27/11/2015 at about 8 p.m., the claimant was coming from Hassan Circle to IB Circle as pedestrian for taking photos of Kanakadasa Jayanti on left side of the road, NH 206. When he reached near Government Boys College, at that relevant point of time, on one motorcycle bearing registration number KA 44 or 1719, coming from petitioner's left side with rash and negligent manner as to a cause endangering to human life, and as such, rash and negligent manner of driving of the motorcycle dashed against the petitioner. My lord may kindly see that the accident has coming from the petitioner's left side. That is, petitioner's left side means he is in the middle of the road. In the left side of the petitioner, that accident, that vehicle has come. It is the case of the petitioner also. In this accident, the petitioner was grievously injured. Due to this accident, the petitioner fell down and caused injuries to his neck, knees, leg, and waist.
Oh, that is his case.
Yes.
Everything is against you, but you have not examined any witnesses. Disprove that.
No, my lord. The case should
Yes,
stand.
if you want, I will give a finding here itself for entire merit.
Once
Or you want to release that apply on the copy. If you want, I will give a finding now itself.
one submission.
No, you have not disproved examining any evidence.
One submission.
You are not examining anybody.
Yes, my
He
lord.
has examined. FIR is against you. Charge sheet is there. To disprove what is there, the driver of that vehicle has not been examined.
One submission, my lord. One submission, my lord.
No, at any cost, he is entitled for at least 50%. I will permit him to withdraw that.
Hello, one submission, my lord. I will leave it to you. Leave it to my lord afterwards. One submission, my lord. Here, the case made out. He has not put intention. He has not produced the spot sketch. The case should stand on its own legs. It is not.
No, sir.
I cannot.
If he is not produced the spot sketch, is it disabled for him to claim a compensation? Which is the law, Mr. Show me that.
Let me permit me to
You produce. It is a public document.
One
You
submission.
are not ready to examine witnesses.
One submission, my lord. Let me submit. The case should stand on its own leg. I cannot prove negative this one evidence or negative this one, my lord.
No, if that sketch is in your favor, you could have produced that.
Yes, my lord. No, case should stand on its own leg, my lord. That's why I filed the appeal. That's why I filed the appeal.
Yes.
The case should stand on its own legs. He has to prove under section 166 of the Motor Vehicles Act, the burden is upon the petitioner to prove that the offending vehicle, the rider of the offending vehicle was negligent. Therefore, it is his burden. He has not carried out his burden.
Yes. Yes, that's all.
Yes, madam.
Yes. Yeah.
But all, the honorable court, in spite of that, if at all inclines to grant 50% of the deposited amount may be released, madam.
Oh, you want a finding or you want to permit him to release that amount?
Madam, that is my submission. But in spite of that, if it is inclined to grant the release amount, 50% of the deposited amount may be released.
Is it a case of death or injury?
Injury, madam.
How much it is awarded?
Awarded is
how much it is deposited here?
280, my lord. 1,64,340 plus 25,000 is deposited.
That 34,640.
Yes. IA 1 of 2023 is filed for releasing that amount. For the reasons stated in the accompanying affidavit, IA is allowed. The claimant is permitted to withdraw that amount collected by the appellant before this court, subject to result of this appeal. The registry is directed to release that amount in favor of the claimant after due verification.
Much obliged.
ಈಗೇನ್ ಆನ್ಲೈನ್ ಬೇಡ ಬಂದು ತಗೊಂಡೋಗ್ರಿ ಐಡೆಂಟಿಫಿಕೇಶನ್ ಬೇಕು ನಮ್ಗೆ. You what online you want? What digital payments? There is a direction to release. क्या क्या है? क्या है? Online ಮತ್ತೆ ಹೆಂಗ್ ಕೊಡ್ತಾರೆ ಈಗ? ಆನ್ಲೈನ್ ಇಲ್ಲ ಅಂದ್ರೆ ಹೆಂಗ್ ಕೊಡ್ತಾರೆ ಅಂತ ನಾನು ಕೇಳಿದ್ದೆ. ಯಾಕೆ ಕೊಡಲ್ವಾ ಚೆಕ್? ಅಲ್ಲ ಈಗ ನಾವು ದಿನ ರಿಲೀಸ್ ಅಂತ ಬರೀತೀವಲ್ಲ, ಏನ್ ಮಾಡ್ತಿದಾರೆ ಅವಕ್ಕೆಲ್ಲ? ಇದರ ಮುಂದೆ ಹೋಗಿ ಅಲ್ಲ ಆರ್ಡರ್ ಆಗಿ ರಿಲೀಸ್ ಆಫ್ಟರ್ ಡ್ಯೂ ವೆರಿಫಿಕೇಶನ್ ಥ್ರೂ ಆನ್ಲೈನ್.
Second year for appellant Vishwanath Pujari K.
Yes.
There's one more connected appeal is made.
Yes, week's time is granted to do the needful on this matter along with that zones. Yes. It is granted to do the needful. In addition, the office is directed to secure original records from the tribunal. Yes, 15. For dispensation of notice to R1 is dispensed. Ready?
Ready,
With a discussion.
Para number 18, judgment page number 19.
Yes.
PW for doctor has been
Doctor who
examined.
examined the petitioner has stated that petitioner has like and those support whole body disabilities is 18%. ಯಾಕೆ ಇದು ಹೇಳಿಲ್ವಾ ಅವರು? ಎಲ್ಲಿದೆ ಅದು?
Surgery done only tibia fracture.
ನಿಮ್ ಡಿಸಬಿಲಿಟಿ ಎಷ್ಟು ಹೇಳಿದ್ದಾರೆ? ಅಲ್ಲಿ 18% correct ಇದೆ. Same in respect of last matter. Last matter he has not said, but we have extracted in that cross examination. What is it? Yes. 5.3 ಅಲ್ಲಿ 18.8. ಎಷ್ಟು ದಿನ ಹಾಸ್ಪಿಟಲ್ ಅಲ್ಲಿ ಇದ್ರಿ? How many days? 5 days. Pain and suffering. Loss of income during the later period ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ? 9%.
9% and 6%.
Yes, that's all. Also, learned counsel appearing part. Limit has contended that To that extent, claimant has suffered previous injury. Doctor has been examined as PW2. In his evidence, he has deposed that claimant has suffered 55% disability to particular limb and 18.33% to whole body. The tribunal has assessed whole body disabilities. 10% is on lower side. Further contended that due to that accident, claimant has suffered previous injury. He was inpatient.
5 days balance.
ಎಷ್ಟು income ಎಷ್ಟು ಹೇಳಿದ್ರಿ ನೀವು? Correct. He was inpatient for a period of
5 days.
5 days. He has suffered lot of pain during the treatment. He has suffered this disability and unhappiness throughout his life. Compensation awarded by the tribunal, pain and suffering, loss of immunities, other incidental expenses is on lower side. Hence, he sought for enhancement of compensation. For contra, P.D. Pradeep, learned counsel appearing for this company, has contended that the claimant has examined the doctor. Doctor has deposed that claimant has suffered 18% disability to whole body. Considering that evidence of doctor and injury suffered by the claimant, tribunal has rightly assessed whole body disability is 10%. Secondly, he has contended that the injury suffered by the claimant is minor in nature. He was inpatient only for a period of 5 days. Considering that evidence of doctor and injury suffered by the claimant, compensation awarded by the tribunal, pain and suffering, loss of immunities, other incidental expenses, just and reasonable. Lastly, he has contended that interest awarded by the tribunal, 9% is on higher side. Hence, he sought for dismissal of the appeal. Heard the learned counsel for the parties. Views, judgment and award. It is not in dispute. Claimant has suffered an injury in the road traffic accident occurred on 12/2/2020 due to rash and negligent driving of driver of car bearing registration number KA51 MK 2682. Due to that accident, claimant has suffered the following injury. Dr. Avinash Parshathi has been examined as PW4. In his evidence, he has categorically deposed that the claimant has suffered permanent physical impairment of 55% and whole body disabilities is 18.33%. Considering that evidence of doctor and injury suffered by the claimant, the whole body disabilities has to be assessed 18.33%. Tribunal has rightly assessed notional income of the claimant as 14,500. The time of the accident, he was aged about
26 years.
26 years.
26.
26
years.
Multiplier applicable to that age group is 17. Party. Loss of future earning has been reassessed as follows. Due to the accident, the claimant has suffered the aforesaid injury. Inpatient for a period of 5 days. He has suffered a lot of pain during the treatment. He has suffered this disability and unhappiness throughout his life. Considering that evidence of doctor and injury suffered by the claimant, I am inclined to enhance the compensation for pain and suffering from 50,000 to 60,000. Loss of income during the later period granted for 2 months. The compensation awarded by the tribunal in the other hand are just and reasonable. Hence, compensation amount carries 6% interest. Yes. Ready. This R1 is dispensed at the risk of the R2 is dispensed at the risk of the appellant. delay 502 days, 503 is condoned, not entitled. Yes. 2018. Yes, sir. Earning is 2 lakhs per annum. ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ 18 ಗೆ ಎಷ್ಟಿದೆ ಫ್ಯೂಚರ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ಸ್ ಕೊಟ್ಟಿದ್ದಾರಾ
ಕೊಟ್ಟಿದ್ದಾರೆ
25% ಕೊಟ್ಟಿದ್ದಾರೆ ಯಾಕೆ ಇಫ್ ಚಿಲ್ಡ್ರನ್
there's a clear finding on that 13 a judgment at page number 13 Malon. Internal page 13 Lord, it is the petitioner stated that third petitioner is suffering from illness, that is seizures, and he was dependent on the disease. To prove the same petitioner relied on discharge summary of February. The patient name is shown as Satish and diagnosis is new onset seizures. It is worth to know that except P16 nothing is pleaded and proved to demonstrate that third petitioner was dependent of the disease. There is no material placed on record that he was dependent on the disease.
First being the wife, deceased is the dependent, petitioner but two are the major sons. Petitioner stated that the ಅಲ್ಲಿಗೆ ಆಯ್ತಲ್ಲ 1/3 ಒಬ್ರು ಆದ್ರೆ ಸಾಕಲ್ಲ ಅಲ್ಲಿ ವೈಫು ಮತ್ತೆ ಇನ್ನೊಬ್ರು ಸನ್
ಅಲ್ಲ ಇನ್ನೊಬ್ರು ಸನ್ ಅವ್ರು ಪ್ರೂವ್ ಮಾಡಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ ಅದನ್ನ
ಒಬ್ರು ಪ್ರೂವ್ ಮಾಡಿಲ್ಲ ಒಬ್ರು ಪ್ರೂವ್ ಆಗಿಲ್ಲ ಒಬ್ರು ಈಸ್ ಏನ್ ಡಿಸೇಬಲ್ಡ್ ಮ್ಯಾನ್ ಯು ರೀಡ್ ದಟ್ loss of dependency para 2 and 3 are the major son. Petitioner stated that the third petitioner
except discharge summary nothing is placed on record to prove that he is suffering from illness and he is
dependent on the disease. To prove the same petitioner relied on discharge summary of the Victoria Hospital wherein the patient's name is shown as Satish so and so. Nothing is pleaded and proved that demonstrated that third petitioner was an dependent of the. No, they have stated that he is depending.
He is depending, but there is no material except discharge summary. There is no material placed on record.
As you disprove by cross examination. See, tribunal has taken the contention. They are a major.
Two sons are majors.
Just because in a major, they cannot be say that they are not depending.
Yes.
They have given evidence. But if you are in the cross examination elicited that they have their own income, they are not depending. Then otherwise, it according to that 2 and 3 both has to be considered. Not only 3. 2 has to be considered. But given the medical records has been produced that he is
only discharge
suffering from the seizure.
Only discharge summary.
That is enough. Seizure is a permanent disability. It is not that curable. Yes. Consortium.
40,000.
120 hours. Interest 7.5 again. That will be 6.6% for enhancement. Don't show learned counsel appearing for the claimant has contended that the time of the accident, deceased was aged about 50 years, was earning 2 lakhs per annum by doing agriculture and milk vending business. Criminal has assessed notional income of the deceased as 12,000 rupees per month is on lawyer side. Secondly, he has contended that there are 3 dependents. The tribunal has deducted 50% of the income of the deceased instead of deducting 1/3. The same is instead of deducting 1/3. Third, he has contended that in view of judgment of apex court in case of magma, the claimants are entitled 40,000 each. Hence, he sought for enhancement of compensation. The contra, so and so learned counsel appearing for the insurance company has contended that even though the claimant has claimed that deceased was earning 2 lakhs per annum by doing an agriculture and milk vending business, but they have not produced any document to establish the same. Therefore, tribunal has rightly assessed notional income of the deceased as 12,000 per month. Secondly, he has contended that dependent number, the claimant number 2 and 3 are the major sons. They are not depending upon the income of the deceased. Therefore, tribunal has rightly deducted 50% of the income of the deceased for personal expenses. Also, he has contended that considering that age and avocation of the deceased, the overall compensation awarded by the tribunal is just reasonable. The interest awarded by the tribunal, 7.5%, is on higher side. Hence, he sought for dismissal of the application. But the learned counsel for the parties, those judgment and award is not in dispute. Shankarappa died in road traffic accident occurred on 3rd April 2018 due to rash and negligent driving of driver of car bearing registration number KA03 MR 8219. Even though claimant has claimed that deceased was earning 2 lakhs per annum by doing an agriculture and milk vending business, they have not produced any document to establish the same. The notional income has to be assessed on the basis of guidelines issued by Karnataka Legal Service Authority. For the accident occurred in 2018, notional income has to be considered as 12,500. A specific case of the claimants that the claimants number 1 to 3 are depending upon the income of the deceased. It is also imposed by the PW1 that the claimant number 3 is suffering from illness, seizure, and he was depending upon the deceased. To disprove the same, nothing worthwhile has been initiated in the cross-examination of the PW1 by the defendant. So, 1/3 of the income of the deceased has to be deducted for personal expenses. The tribunal has rightly added 25% of the income of the deceased for future prospects. Particular applicable to the age group, which is 13. For the loss of dependency has been reassessed as follows.
3,125, 3,625.
Listen, 50,000 for loss of estate, 50,000 for funeral expenses, due of judgment of apex court in case of MECMA, that is entitled 40,000 for spousal consortium. But 2 and 3 are entitled 40,000 each for parental consortium. Enhanced compensation amount carries 6% interest. In view of order dated so and so, the claimant is not entitled for the interest for enhanced compensation amount for a period of 503 days.
I am appealing for the respondent, my lord.
Ready?
Ready, Swami.
Yes. Notice to R1 is dispensed. We have 26 days is controlled. Yes, sir. Even accident. Come on. Correct ಆಗಿದ್ದೀರಾ? ಎಷ್ಟು ನೀವು ಕ್ಲೈಮ್ ಮಾಡಿರೋದು? 40,000. ಟ್ರಿಬ್ಯುನಲ್ ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ? 14. ಇವರಿಗೆ ಎಷ್ಟಿದೆ? 15,000. What is his age? 59 years. 10%. Second. Where is that discussion?
Page 15, para 12, my lord. Para 12, page 15, my lord.
Deduction towards that personal. For correct ಮಾಡಿದಾರಾ? Yes. What about that this thing? Love and affection, funeral ಅವೆಲ್ಲ ಜಾಸ್ತಿ ಕೊಟ್ಟಿದಾರ? 60, 25, 25, 50 ಕೊಟ್ಟಿದಾರ? ಎಷ್ಟು ಜನ ಇದ್ದಾರೆ? 3 ಜನ. ಗ್ರ್ಯಾಂಡ್ ಏನ್ ಬರಲ್ಲ? ಏನಿಲ್ಲ. ವೈಫ್ ಕ್ಲೈಮೇಟ್ ನಂಬರ್ 1 is the wife. 2
ಮೈಲಾರ್ಡ್ ಇದರಲ್ಲಿ ಒಂದು ಟೆಕ್ನಿಕಲ್ ಎರರ್ ಇದೆ ಮೈಲಾರ್ಡ್. ಲರ್ನೆಡ್ ಜಡ್ಜ್ ಕೂಡ ತಪ್ಪು ಮಾಡಿದ್ದಾರೆ, ಬಟ್ ನಾನು ಅಪೀಲ್ ಅಲ್ಲಿ ಇಲ್ಲ. ಬೆಸ್ಟ್ ಐ ವಾಂಟೆಡ್ ಟು ಬ್ರಿಂಗ್ ಇಟ್ ನೋಟಿಸ್ ಆಫ್ ದಿಸ್ ಕೋರ್ಟ್. 3 ಜನ ಮ್ಯಾರಿಡ್ ಡಾಟರ್ಸ್, 1 ಗ್ರ್ಯಾಂಡ್ ಸನ್, 1 ಮೇಜರ್ ಸನ್. ಆಕ್ಚುಯಲ್ ಆಗಿ ಅಪೀಲ್ ಇದ್ರೆ ನನ್ನ ತಮ್ಮ ಕೋರ್ಟ್ ಮುಂದೆ 50% ರಿಡಕ್ಷನ್ ಮಾಡ್ಬೇಕು ಅಂತ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅವರು ವಿನಿಶ್ ಚೇನ್ ಕೇಸಲ್ಲಿ ಕೂಡ ಹೇಳಿದ್ದಾರೆ. ಬಟ್ ಹಿಯರ್ ಐ ಆಮ್ ನಾಟ್ ಇನ್ ದ ಅಪೀಲ್. ದಟ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಕರೆಕ್ಟೆಡ್ ಬೈ ದಿಸ್ ಕೋರ್ಟ್ ಮೈ ಎನ್ಹಾನ್ಸಿಂಗ್ ದಿ ಕಾಂಪನ್ಸೇಷನ್ ಮೈಲಾರ್ಡ್.
Now wife, who is that first this thing?
3 major daughters, my lord. Married daughters, major and married, living with their husbands.
Let us see.
Please,
First is the wife. Wait. First is the wife. Second daughter married. She is living separately with that husband. Second is Mohan Yamma, son of late Ramanna, grandson late Malika. Yes, he is depending. So ಯಾರದು? ಮಗ. ಅಲ್ಲಿಗೆ 1, 2, 3 ಆಯ್ತು. ಇವರು 5ನೇ ಯಾರು? She is married. 6 married. ಅಲ್ಲಿಗೆ 3 ಅಂದ್ರೆ 1/3. 1/4 ಮಾಡಿದ್ದಾರೆ, 1/3 ಆಗುತ್ತೆ. ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ? 0.5. ಎಸ್ ಮಿಸ್ಟರ್ ಲಕ್ಷ್ಮೀ.
ಇದರಲ್ಲಿ ಗ್ರ್ಯಾಂಡ್ ಸನ್ ಮತ್ತೆ ಮ್ಯಾರಿಡ್ ಡಾಟರ್ಸ್ ಗೆ ವಿನೀಶ್ ಜೈನ್ ಕೇಸ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅವ್ರು ಹೇಳಿದ ಪ್ರಕಾರ ಬರುವುದಿಲ್ಲ. 50% ತಗೋಬೇಕಿತ್ತು. ನಾನು ಅಪೀಲ್ ಅಲ್ಲಿ ಇಲ್ಲ, ಬಟ್ ದೇ ರೆಸ್ಟ್ರಿಕ್ಟೆಡ್ ಟು 15 lakhs ಟೋಟಲ್ ಅವಾರ್ಡ್.
Grandson is living with them.
ಇಲ್ಲ, there is no such document placed before the learned judge, my lord, even before this court also. ಆ ಮ್ಯಾರಿಡ್ ಆಗ್ಬಿಟ್ಟು
What is the evidence?
my lord, please come to evidence of PW1. ಒಬ್ಬರನ್ನೇ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿರೋದು ಮಗನ್ನ, ಸಂತೋಷ್ ಅನ್ನೋರ್ನ.
What is the age of the grandson?
ಅವನಿಗೆ 17 ವರ್ಷ. ಅವರು ತಂದೆ ಹೆಂಡತಿ ತಾಯಿ ಜೊತೆ ಇರ್ತಾರೆ ಹೊರತು ಅಪ್ಪ ತಾತ ಮನೆಯಲ್ಲಿ ಇರ್ತೇನೆ ಅನ್ನೋದಕ್ಕೆ ಏನು ಪ್ರೂಫ್ ಇಲ್ಲ.
Both are not alive, father and mother.
ಆತರ ಎವಿಡೆನ್ಸ್ ಇಲ್ಲ ಮೈಲಾಡ್ ಕೋರ್ಟ್ ಮುಂದೆ.
ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಎಲ್ಲಿದೆ?
PW1 ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ತಗೊಳ್ಳಿ ಮೈಲಾಡ್.
ಅಲ್ಲ, PW1 ಎವಿಡೆನ್ಸ್ ಕೊಡಿ.
ಪ್ಲೀಸ್. ವಾಂಟರ್ಲಿ ದೇ ಕಮಿಟೆಡ್ ಎನ್ ಎರರ್. ದಿ ಕ್ಲೈಮೆಂಟ್ಸ್ ಎಲ್ಲಾರ್ದು ಆಧಾರ್ ಕಾರ್ಡು, ರೇಷನ್ ಕಾರ್ಡ್ ಹಾಕ್ತಾರೆ. ಇವ್ರದ್ದು ಸತ್ತೋದವ್ರದ್ದು ಕ್ಲೈಮೆಂಟ್ ಮರಿ ಕಂಚಿಕಾಯಿ ಅವ್ರದ್ದು ಮಾತ್ರ ಹಾಕುವುದಿಲ್ಲ. ನಮ್ಮ ಹತ್ರ ಇಲ್ಲ, ಕಳೆದೋಗ್ಬಿಟ್ಟಿದೆ ಎಲ್ಲ ನೋಡಿ ಸುಮ್ಮನೆ. PW1 ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಕೈಂಡ್ಲಿ ಬಿ ಲುಕ್ಡ್ ಇಂಟು ಮೈ ಲಾರ್ಡ್.
ಯಾರದು? ಮಗ. ಸನ್ ಇದನ್ನಲ್ಲ?
ಸನ್ ಇದಾನ ಸ್ವಾಮಿ. ಸನ್ ಇಲ್ಲ ಅಲ್ಲ, ಮೇಜರ್ ಸನ್ ಅಂತ ಹೇಳಿದೆ ಅಷ್ಟೇ.
ಮೇಜರ್ ಸನ್ ಬೈ ಇಟ್ ಸೆಲ್ಫ್ ಇಸ್ ನಾಟ್ ಎನಿ ಡಿಸ್ಕ್ವಾಲಿಫಿಕೇಶನ್.
ಇಲ್ಲ ಅದಲ್ಲ, ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ದಯವಿಟ್ಟು ನೋಡಿ ಮೈ ಲಾರ್ಡ್.
That son, this is also Mallikaran Sira with some rules. What is direction? Immediately accident. This is my father, Mallikaran. Daughter. Where is that cross examination? Which paragraph, Mr.
ಮೈ ಲಾರ್ಡ್, ಮುಖ್ಯ ವಿಚಾರಣೆ ವಾದಿ ಪರ ಶ್ರೀ ವಕೀಲರಿಂದ 25/5/22 ಸಾಕ್ಷಿಯನ್ನು ಕರೆಸಿ ಸತ್ಯ ಪ್ರತಿಜ್ಞೆ ಬೋಧಿಸಲಾಯಿತು. ಅಲ್ಲಿಂದ ಶುರು ಆಗುತ್ತೆ ಮೈ ಲಾರ್ಡ್. ನಾನು ನನ್ನ ಸಾಕ್ಷಿ ಪ್ರಮಾಣ ಪತ್ರವನ್ನು ಹಾಜರುಪಡಿಸಿದ್ದು ಅದರಲ್ಲಿ ಬರೆದಿರುವ ಎಲ್ಲಾ ಮಾಹಿತಿಗಳು ಸತ್ಯವಾಗಿರುತ್ತವೆ. ಅದನ್ನು ಬರೆಯಲು ನಮ್ಮ ವಕೀಲರಿಗೆ ಮಾಹಿತಿಯನ್ನು ನಾನೇ ನೀಡಿರುತ್ತೇನೆ. ಅದರಲ್ಲಿರುವ ಎಲ್ಲ ಅಂಶಗಳನ್ನು ಅರ್ಥೈಸಿಕೊಂಡು ಅದಕ್ಕೆ ನಾನು ಸಹಿ ಹಾಕಿರುತ್ತೇನೆ. ಗುಬ್ಬಿ ಪೊಲೀಸ್ ಠಾಣೆ ಅಪರಾಧ ಸಂಖ್ಯೆ ಸೋಣಸು ಪ್ರಥಮ ವರ್ತಮಾನ ದೂರು ಸ್ಥಳ ಪಂಚನಾಮೆ
ಒಟ್ಟು 5 ಜನ
ಪಾರ್ಟಿ ಸವಾಲು ಬನ್ನಿ ಮೈಲಾ.
2 ಗಂಡು ಮಕ್ಕಳು ಅಕ್ಕ ತಂಗಿ ಅವರಿಗೆ 70 ವರ್ಷ ಆಗಿದ್ದು ಅದರ ಮರಿಮಕ್ಕಳು ಕಾರ್ಡ್ ಹೋಗಿದೆ. ನನ್ನ ತಂದೆಯವರು ಆಧಾರ್ ಕಾರ್ಡ್ ಮಾಡಿಲ್ಲ. ನಾನು ಪೊಲೀಸ್ ಹೇಳಿ
ಅದು ಕಳೆದೋಗಿದೆ. ಎಲ್ಲರದ್ದು ಹಾಕ್ತಾರೆ, ಇವರೊಬ್ಬರು ಮಾತ್ರ ಕಳೆದೋಗುತ್ತೆ. ಬಿಕಾಸ್ ಬೆಸ್ಟ್ ನೋನ್ ಟು ದೆಮ್.
No, this is for your cross-examining only for his income. You have not cross-examined regarding that that claimants are not depending upon his income. Nowhere it is cross-examined. You chose
ಅದು ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಮಾಡಿಲ್ಲ.
our evidence ಹೇಳಿದ್ಮೇಲೆ ನೀವು disprove ಮಾಡಲಿಲ್ಲ ಅಂದ್ರೆ you have to be accept. It is a summary proceedings, is it not?
ಅಲ್ಲ, ಒಪ್ಕೊಳ್ತೀನಿ ಮೈಲಾಡ್. ಅದನ್ನ ಹಾಗಂತ ಮೈಲಾಡ್ ಒಂದು ಸಬ್ಮಿಷನ್ ಈ ಕೋರ್ಟ್ಗೆ 2018 ACJ 1004 ಸ್ವಲ್ಪ ನೋಡ್ಬೇಕು ಮೈಲಾಡ್. ವಾಟ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಸೆಡ್ ಇನ್ ಸಚ್ ಎ ಕೇಸ್.
Such a case ಅಂದ್ರೆ ಯಾವ ಕೇಸ್?
ಇದೆ ಸೇಮ್ ಮ್ಯಾರಿಡ್ ಡಾಟರ್ಸ್ ಮೇಜರ್ ಸನ್ಸ್ ಇರುವಾಗ ವಾಟ್ ಈಸ್ ದಿ ರೆಲೆವೆನ್ಸಿ?
No, if it is proved they are not depending, where is that judgment?
ಮೈಲಾಡ್ 2018 ACJ 1004 ಹೆಡ್ ನೋಟ್.
Head note ಅಲ್ಲ ಓದ್ಬೇಡಿ.
ಸರಿ, ಪ್ಯಾರಾ 7 ಬನ್ನಿ ಮೈಲಾಡ್.
What is the facts of the case?
ಸೇಮ್ ಇಶ್ಯೂಸ್ ಮೇಲೆ ಮೈಲಾಡ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಡಿಸಿಷನ್ ಬಂದಿರೋದು. Shall I read the relevant portion, my lord?
Wait. You have yet to get the book.
Oh, sorry, sir. Right. This is the
Sir, where is that, Mr.? Nothing is there in the discussion. It is only a one para. On your appeal, you said there are number of judgment, even major sons, if they are depending, they are entitled. Yes. Yes, I will consider your service.
please, my lord.
So and so. That council appearing for. Direct has contended that. At the time of the accident, deceased was earning per month. As assessed, personal income of the deceased as 14,000 per month is on lawyer side. Further contended that at the time of the accident, deceased was aged about 59 years. In view of judgment of apex court in case of Kanai 10% of the income of the deceased has to be added for future prospects. Lastly, he has contended that in view of judgment of apex court in case of Magma, the claimants are entitled 40,000 each. Yes, he sought for enhancement of compensation. For contra, Lakshmi Narsimaya Learned Council appearing for insurance company has contended that even though claimant has claimed that deceased was earning 40,000 per month, they have not produced any document to establish the same. Therefore, tribunal has rightly considered 14,000 notional income of the claimants as per month. He further contended that the claimants number, the claimants number 1 is alone is depending upon the income of the deceased. Claimant number 2 to 4 are the major son and married daughter. They are not entitled for income of the deceased. Therefore, tribunal, instead of deducting 50% of the income of the deceased for personal expenses, has deducted 1/4. Lastly, he has contended that considering that age and avocation of the deceased, overall compensation awarded by the tribunal is just and reasonable. The interest awarded by the tribunal, 7.5% is on higher side. Total 9%. 7.5 to
9% my lord. Interest to ಜಾಸ್ತಿ ಇದೆ my lord.
9% is on higher side. Hence, he sought for dismissal of the appeal. Heard the learned counsel for the parties. Those judgment and award. It is not in dispute. Marka Chennangaya was died in road traffic accident occurred on 13/4/2021 due to rash and negligent driving of driver of car bearing registration number KA01 MA 9388. Even though claimant has claimed that he was earning 40,000 per month, he has not produced any document to establish the same. To assess notional income, the guidelines issued by Karnataka Legal Service Authority has been considered. As per that guidelines, for the accident occurred in 2021, notional income has been fixed as 15,000. Accordingly, notional income of the deceased has to be considered as 15,000 per month. At the time of the accident, deceased was aged about 59 years. In view of judgment of apex court in case of pronouncement, 10% of the income of the deceased has to be added for future prospects. There are 6 claimants. In the evidence, they have claimed that they are depending upon the income of the deceased. Since the claimant number 2, 5, 6 are the married daughters. They are living separately. They are not depending upon the income of the deceased. Considering the evidence of the parties, the claimant number 1, claimant number 2 arable, 2 illa. Claimant number 1 and claimant number 4, 3 and 4 are depending upon the income of the deceased. Therefore, the 1/3 of the income of the deceased has to be deducted for personal expenses instead of 1/4. At the time of the accident, deceased was aged about 59 years. The multiplier applicable to that age group is 9. Accordingly, loss of dependency has been reassessed as follows.
15,000 plus 6,500, 100%, 6,500, minus 5,500, 11,000. 11,000, 12 into 9, 11,88,000.
In addition, 15,000 for loss of estate, 15,000 for funeral expenses. Claimant is entitled 40,000 for spousal consortium. Claimant number 2, 4, 5, 6 are entitled 40,000 each for parental consortium. The enhanced compensation amount here is 6% interest. Accordingly, appeal is allowed in part.
My lord, one submission, my lord.
Yes.
ಇದರಲ್ಲಿ ಅವರು they are before this court claiming only 15 lakhs, my lord. Kindly see after their claim picture appeal before this court at after para number 9. The appeal appellants have claimed 45 lakhs before the MACT and MACT awarded 12 lakhs 94,000. Hence, miscellaneous first appeal has valued at 32 lakhs 6,000. However, the appellants restricted their claim to 15 lakhs and the same value of this appeal.
Supreme Court said it can be enhanced. It is for a just compensation.
Sorry, sir. Our restrict ಮಾಡಿದ್ದನ್ನ ತಮ್ಮ court ನಲ್ಲಿ
Restrict, the correct. In that, I think one of my case also is there. It is reported. I think D. Vijay Kumar has argued this court can't grant more than 15 lakhs. I have answered that.
It is only a purpose of jurisdiction. It is a
Yes.
very simple matter.
Please.
Not entitled? No, not that. Class appeal alla. ಅವರು ಕ್ಲೈಮ್ ಮಾಡಿರೋದಕ್ಕಿಂತ ಜಾಸ್ತಿ ಇಟ್ ಇಸ್ ಎ ಜಸ್ಟ್ ಕಾಂಪನ್ಸೇಷನ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಮೋಹನ್ ಶಾಂತನ್ ಕೊಟ್ಟದ ಜಡ್ಜ್ಮೆಂಟ್ ದಟ್ ಇಸ್ ವಾಟ್ ದಟ್ ಹಿ ಸೆಡ್ ಹಿ ಕಾಂಟ್ ಗಿವ್ ಗ್ರಾಂಟ್ yes
claimants in this matter road.
Yes.
Claimants have filed an application seeking release of the 50% of the award amount deposited by them.
Now that who has filed this appeal?
The insurance company has filed this appeal.
Ravi Shankar. Waiting service of releasing of amount. What is that on what ground they are challenging, Mr.?
Firstly, they are on the ground that the tribunal was supposed to take 4,000 income per month. It is correct. Trial court has awarded has taken 8,000. Accident is of the year.
Liability and dispute money.
2002. Liability is already confirmed by this honorable court. This is third round of appeal. May pass on this judgment. In the very same case.
Why that matter has been remanded?
They had disputed the liability para 19. Para 19 and page 19. They had disputed the relationship between the employer and employee. And this court has held that there exists
the relationship of the employer-employee definitely exists among the also. It is clarified. It's for the commissioner of the workmen's to adjudicate the remaining aspect with regarding to the merit of the case.
Please.
Existing of the relationship, employer-employee relationship is there. Whether accident is occurred during the course of the employment and compensation.
Please, madam. So accident is admitted.
Now, are they taking any contention in the appeal? It is not during the course of the employment.
No, madam.
Then
they have taken the contention.
Only that reduction is only in respect of that 8,000 to 4,000.
4,000 ಗೆ ಆಮೇಲೆ ಇನ್ನೊಂದು ಕಂಟೆನ್ಷನ್ ತಗೊಳ್ತಾರೆ.
You get it?
Please.
Yes, you get it. We will consider. Also. Yaudo? 19. Yes. It is to respondent. Padi. Memo. Notice to R1 is dispensed at the risk of the appellant. One time, sir. Yes. You condone the delay. Delay of 17 days in filing an appeal is condoned. IA 1 of 2023 is allowed. Yes. Records beka. Office is directed to secure original records from the tribunal. Yes. Yes. Learned counsel for the appellant has filed a memo. Leave of this court to withdraw this appeal. Memo is taken on record. The above appeal is dismissed as withdrawn.
Number 21, Girish Paladar for appellant.
We will take. Obrena. Yes, D. Vijay Kumar is directed to take notice for R1. Learned counsel for the appellant is directed to serve one set of copies. Sorry, copy.
We appear for the appellant, my lord. It's a case of injury.
United India, Patil, you were there.
Served unrepresented.
Mr. Reddy, you were there. Yes. Respondent number 2, served unrepresented. Reddy is directed to take notice. Madam, Shankar Reddy, go on copy.
Please.
Appellant is directed to serve one set of copies on Shankar Reddy. Yes.
Date may be fixed, my lord.
Next week, you serve copy, then we will get ready. Yes.
Please.
Please. Notice on IA 1 of 2023. ಯಾರನ್ನ ಇಂಪ್ಲೀಟ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
ಆಫೀಸಲ್ಲಿ ಅಬ್ಜೆಕ್ಷನ್ ಮಾಡ್ತಾರೆ, ಇವ್ರ ಕೇಸಲ್ಲಿ ಅಬ್ಜೆಕ್ಷನ್ ಮಾಡೋದು.
ವಿಜಯ್ ಕುಮಾರ್ ಡಿ ವಿಜಯ್ ಕುಮಾರ್ ಅಂದ ತಕ್ಷಣ ಆಫೀಸರ್ ಅಬ್ಜೆಕ್ಷನ್ ಮಾಡ್ತಾರೆ. ಯಾರು whom you want to implement? Why? ನೋಡಿ, ಇವ್ರದ್ದು ಕೇಸಲ್ಲಿ ನಾನು ಒಂದು ಆರ್ಡರ್ ಮಾಡಿದ್ದೆ. ಡಿವಿಷನ್ ಬೆಂಚ್ ಅಲ್ಲಿ 30% is liable for the corporation. 30% is ಹಾರ್ಟಿಕಲ್ಚರ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್. ಯಾವ್ದೋ ಸ್ಪೋರ್ಟ್ಸ್ ಇವ್ರು ಮರ ಬಿದ್ದಿರೋದ್ರ ಮೇಲೆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅವ್ರು ಸ್ಟೇ ಮಾಡಿದಾರೆ ನಮ್ಮ ಆರ್ಡರ್. ಹೇಳಿ, ಇವರು ನಮ್ಮ ಶಾಂತರಾಜ್ ಅವ್ರ ಕೇಸಲ್ಲಿ ಆರ್ಡರ್ ಮಾಡಿದ್ರು, ಬಿಕಾಸ್ ದೇರ್ ನೆಗ್ಲಿಜೆನ್ಸ್ ಇಸ್ ದೇರ್. ಬಟ್ ದಟ್ ಹ್ಯಾಸ್ ಬಿನ್ ಸ್ಟೇಡ್ ಬೈ ದ ಸುಪ್ರೀಂ ಕೋರ್ಟ್. ಆಮೇಲೆ ಏನಾಗಿದೆ ಗೊತ್ತಿಲ್ಲ. No, why it is stayed, we don't know. Whether they cannot be fixed the liability and all, but I said that they have also liable on that. ಅದೊಂದು ನೋಡಿ
Is application not maintainable in this proceeding? This is an accident. Damages ಬೇಕಾದ್ರೆ ಹಾಕೊಳ್ಳಿ ಅವ್ರ ಕಡೆ.
ನೋಡೋಣ, ಲೆಟ್ ದೆಮ್ ನೋಟಿಸ್. ಅದರಲ್ಲಿ ಅವರು ಅಲ್ಲಿ ಪಾರ್ಟಿ ಟ್ರಿಬ್ಯುನಲ್ ಅಲ್ಲಿ tribunal has dismissed their liability on them. Insurance company appeal ali I said there also. Yeah, I think Patil Padma has argued at the consultation. ಅದೇನಾಗಿದೆ ಅಂತ ಒಂದು ನನ್ನ ಅಪೀಲ್ ಅಲ್ಲಿ ಪದ್ಮ ಸ್ವೀಟ್ ಪಾಟೀಲ್, ಯುವರ್ ಕಲೀಗ್ ಪದ್ಮ, ಆ ಒಂದು ಅಪೀಲ್ ಅಲ್ಲಿ ನಾನು ಜಸ್ಟಿಸ್ ಆರಾಧ್ಯ ಅವರು ಇದ್ದಾಗ ಶಾಂತರಾಜ್ ಕೇಸಲ್ಲಿ she has argued that they are also liable anta. Then I said corporation is also 30% liable anta. Supreme Court ಗೆ ತಗೊಂಡೋಗಿ ಸ್ಟೇ ಆಗಿದೆ only in respect of that liability fixed on the corporation. Others ಅದೇನಾಗಿದೆ you also just verify. Let us see. Yes, notice on IA 1 of 2023.
Number 24, Satish HK for appellant, Gita Raj.
Manager, National Insurance Company. ನೀವ್ ಯಾವ್ದಕ್ಕೆ ಮೇಡಮ್? You will take notice, Gita Raj. Yes. Gita Raj is undertaken to appear for respondent number 2. Delay of 3 days in filing an appeal is condoned. IA 1 of 2021 is allowed. All this matter along with that. Yes. An office is directed to secure original records from the tribunal.
Number 25, number 26,
Yes, ready. Vijay Kumar illela idralla really.
Number 26, Vijay Kumar.
ಬಂದಿದ್ರಲ್ಲ ಬೆಳಿಗ್ಗೆ. Yes, pass over or we'll have next. Yes, delay of 19 days in filing an appeal is controlled. IA 1 of 2021 is allowed. Yes, please this matter next week.
Case number 27,
Lord, I pray for some time to file objections. 2 weeks time may be granted.
Yes,
There is inordinate delay.
Yes. The net counsel for the respondent prays 2 weeks time to file objection to IA 1 of 2021.
XB Rudresh for appellant, Ajit Kalyan.
File an application.
Hmm.
Withdraw the amount deposited.
Yes. You are appearing for whom? Appellant is insurance company no owner.
Owner.
Owner appeal. Why? Huh? Why that an insurance company ಇದೆಲ್ಲ
Yes, when exonerate ಮಾಡಿದ್ದಾರೆ.
ಯಾಕಾಗಿ?
Policy conditions violate ಆಗಿದೆ.
That condition. Attended that owner of the attending lorry had permitted the driver who doesn't have the valid driving license to drive the vehicle. It was made without permit and fitness certificate. Term of its conditions. Yes, if you want settle, you settle that.
ಅವ್ರಿಗೆ ಇಬ್ರು ಲೇಬರರ್ಸ್ ಕೆಲಸ ಮಾಡ್ತಾರೆ ಪೇರೆಂಟ್ಸ್ at least the 5 lakhs may be permitted to withdraw.
Yes, Mr. Anyhow. ಅಲ್ಲ ಎಷ್ಟು ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡಿದ್ರು 50% is their entitled. Even pay and liability ಮಾಡಿದ್ರು ಕೂಡ you are the owner, you have to pay it ultimately. Now whatever that amount you have deposited, it will never come back to you. Therefore let that they have to. ಅಲ್ಲ ಗೊತ್ತಿಲ್ಲ ನಾನು ಹೇಳಿದ ಪೇಂಟ್ ರಿಕವರಿ ಮಾಡಿದ್ರು if owner who is deposited that amount cannot be returned, that has to go to that insurance company. Therefore ultimately he is entitled 50%. I will permit it. There is no. Tell me. No, even if it is settled, he cannot say that I don't want any money. Is it not? At least he wants to settle 50%. 50% deposit ಮಾಡಿರೋದು ಕೊಟ್ಟ. No, you can't understand what I am putting. Even if you succeed for pay and recovery, you are that owner's appeal. Then you have to pay amount. I cannot permitted you to withdraw when there is a pay and recovery. Supreme Court said in the very same proceedings it can be recovered. That means to say that even we can also direct it to recover. That yet cannot be missed. No, will not allow that. No, Mr. Unless I convince myself, I will not permit it to withdraw. See, I have given all options. In all options, if you succeed, he is entitled. Because it is not your case that he is not entitled or that there is no accident has occurred. You are only on the liability. Yes. And you have already deposited. It is not that you have to again, taken a money and deposited money. Is it that case of death or
Case of death.
then who will take care of that? We will have it tomorrow. Wednesday, next Wednesday. Is this matter next Wednesday?
Number 29, for appellant, Vijay Kumar C.
Yes. That is filed by that another claimant. Yes. There is a delay. Adral delay ಇದೆಯೇನ್ರಿ? delay ಕಂಡೋನ್ ಆದ್ಮೇಲೆ ಕನೆಕ್ಟ್ ಮಾಡಿಸಿ. There is a delay of 17 days in filing an appeal. IA 1 of 2021 is filed for condonation of delay. Idan owner appeal. Delay of 17 days is condoned. Call this matter along with that zones. Let us ಬರ್ಲಿ ರಕ ಇದು ಬರ್ಲಿ ಆಮೇಲೆ ನೋಡಿ.
Number 30, Vijay Kumar C. for appellant, current matter, Sohani Volda.
Yes. There is Vijay Kumar. The connected matter notice ಹೋಗಿಲ್ಲಲ್ಲ ಕೊಡಿ. Sanjeev K. Appalent. Chairman, Managing Director, BMTC. You are appearing for BMTC. Yes, in connected matter also you take notice. Yes. Also, the net council is directed to take notice for responding. The net council for the appellant is directed to serve one set of copies. First matterly, 66 days delay in filing an appeal is controlled. IA 1 of 2022 is allowed. Yes. Are you going to copy code connected? Yes.
I'm for respondent, well, we have public explainer, I am representing.
Ready? We have 1096 days in filing an appeal is controlled. The appellant is not entitled for the interest for a period of 7 to date. $3,000.
5,000.
Yes, 14.
8,500.
What is his age? Yes, 25.
48 years.
25.
25%.
30 ಮಾಡಿದಾರಾ?
Deduction 1/5 ಮಾಡಿದ್ರೆ ಅದು 1/4 ಮಾಡ್ತಾರೆ.
ಜಾಸ್ತಿ ಮಾಡ್ಕೋಗ್ಯಾರ. ಹಾ.
Major sons.
4 to 6. 1/4 ಆಗ್ಬೇಕಾ?
1/4.
1/5 ಮಾಡಿದಾರೆ 1/4.
ಮತ್ತೆ ರೇಟ್ ಆಫ್ ಇಂಟ್ರೆಸ್ಟ್ 7.5 ಕೊಟ್ಟರೆ 6%.
Yes, that will consider in terms of so and so. The Senate Council appearing for Senate has contended that at the time of the accident, deceased was earning 15,000 per month. Tribunal has considered notional income of the deceased as 5,000 per month is on lower side. He further contended that in view of judgment of apex court in case of magma, the claimants are entitled 40,000 each. Hence, he sought for enhancement of compensation. For contrast, so and so learned counsel appearing for insurance company has contended that even though claimant has claimed that deceased was earning 15,000 per month, they have not produced any document to establish the same. The tribunal has justified assessing notional income of the deceased as 5,000 per month. Secondly, he has contended that there are only four claimants are depending upon the income of the deceased. Others are major son. They are not depending upon the income of the deceased. Tribunal, instead of deducting 1/4 of the income of the deceased for personal expenses, error in deducting 1/5.
Future perspective.
He further contended that tribunal, while adding future prospects, instead of adding 25%, has added 30%. Contrary to that,
Instead of 30%, they have taken 25%. Instead of 30% has been taken.
yes. Contrary to that law laid down by apex court in case of when I said, lastly, he has contended that the interest awarded by the tribunal 7.5% is on higher side. And she contended that considering that age and avocation of the deceased, the overall compensation awarded by the tribunal is less than reasonable. And she sought for dismissal of the appeal. Heard the learned counsel for the parties, Pharaoh's judgment and award is not in dispute What is that? Shubhan Saab died on 29/11/2014 in a road traffic accident due to rash and negligent driving of driver of the car bearing registration number KA03 MS 1138. Even though claimant has claimed that deceased was earning 15,000 per month, they have not produced any document to establish the same. In other circumstances, notional income must be assessed as per the guidelines issued by Karnataka Legal Service Authority. For the accident occurred in 2014, notional income must be considered as 8,500. There are 4 dependents. In view of judgment of Apex Court, in case of Sarla Verma, 1/4 of the income of the deceased has to be deducted for personal expenses. The tribunal is error in deducting 1/4 of the income of the deceased for personal expenses. Hence, 1/4 of the income of the deceased has been deducted for personal expenses. At the time of the accident, deceased was aged about 48 years. In view of judgment of Apex Court in case of Ganesh, 25% of the income of the deceased has to be deducted for personal expenses. The tribunal error in deducting 30% of the income of the deceased, or adding 30% of the income of the deceased for future prospects. The multiplier applicable to that age group is 13. Accordingly, loss of dependency has been reassessed as follows.
Rate of 25%, 10,625 minus 2,656 at the rate of 1 crore, 7,960.
Listen, 15,000 for loss of estate, 50,000 for funeral expenses. View of Apex Court in case of Nagma, first claimant is entitled 40,000 for spousal consortium. In area 2, 3, 4. Yes, 2 to 6 are entitled 40,000 each for parental consortium. Claimant number 7 is entitled 40,000 for filial consortium. Enhanced compensation amount carries 6% interest. In view of order dated so and so, the claimant is not entitled for the interest for a period of 1,096 days.
Number 32, V.P. Siddaramaiah for appellate, Janardhan Reddy.
Corresponding number 4 measure. Vehicles in involved.
You do it, huh? Yes. What about that delay?
Objection sacrifice of.
Menu. Yes. Learned counsel for respondent number 4 prays 2 weeks time to file objection to IA 1 of 2023. Yes.
Number 33, Chandrasekhar for appellate, Mandula and Tejasvi.
Check. Next week. Do this matter next week.
Number 34, CH-11 for appellate, D. Virgi.
Yeah, 2017. Yes. But it's not examined.
No, my lord.
What is that disability considered by the tribunal?
It's not considered any disability.
What are the injuries, madam? Injury ಏನಾಗಿದೆ? ಟ್ರೀಟ್ಮೆಂಟ್ ತಗೊಂಡಿದ್ದಾರೆ. ಏನೇನ್ ಕೊಟ್ಟಿದ್ದಾರೆ? Yes, Mr.
The regional yeah, 50 to 20,000 global maybe.
ಕೊಟ್ಟಿದಾರಲ್ಲ ಅದಕ್ಕೆ ಪೀರಿಯಡ್ 27 ದಿನ ಕೊಟ್ಟಿದ್ದಾರೆ. ಪೈನ್ ಅಂಡ್ ಸಫರಿಂಗ್ ಸಿನ್ಸ್ ಯು ಆರ್ ನಾಟ್ ಬಿನ್ ಎಕ್ಸಾಮಿನ್ ಡಾಕ್ಟರ್, ಇನ್ನೊಂದು 50,000 ಅಡಿಷನ್ ಮೇಕ್ ಇಟ್ 2,50,000. So learned council appearing for Telecast has contended that due to the accident, Telecast has suffered grievous injury. He has spent 96,837 rupees towards medical expenses. He was inpatient for a period of 15 days. He has suffered lot of pain during the treatment. The compensation, overall compensation awarded by the tribunal, 1,93,837 is on lower side. Hence, he sought for enhancement of the compensation. For contra, Sri Mallikarjun Reddy Learned Council appearing for insurance company has contended that injury suffered by the claimant is minor in nature. He has not examined the doctor. Considering that medical bill and considering that injury suffered by the claimant, the overall compensation awarded by the tribunal is just and reasonable. Hence, he sought for. Lastly, he has contended that interest awarded by the tribunal 8% is on higher side. Hence, he sought for dismissal of the appeal. Heard the learned counsel for the parties. Feroz, judgment and award is not in dispute. Claimant has suffered an injury in a road traffic accident occurred on 24/10/2017 due to rash and negligent driving of driver of Tata Ace bearing registration number KA17 D0538. Due to that accident, the claimant has suffered the following injury. He has spent 96,837 rupees towards that medical expenses, and he was inpatient for a period of 15 days. He has suffered lot of pain during the treatment. Considering that discharge summary and wound certificate exhibit P3 and medical records, I am of the opinion that the compensation awarded by the tribunal 1,93,837 has to be enhanced to 2,50,000. The enhanced compensation amount carries 26%.
There is 218 days. Claim alert.
We have order dated 27/6/2022. It is not entitled for the interest period of 218 days for enhanced compensation.
Number 35, showing the entity for appellant connected matter. This is contributions.
Yes. Hard admit. Yes.
Number 36, the war for appellant. Sugarina.
Yes. Murthy, who is you are Murthy? Yes. Ready?
Ready. Case of death, my lord. Pain recovery order ಆಗಿದೆ.
ಈಗ your claimant are an you both are filed an owner's appeal.
I filed the claimant appeal, my lord. Murthy advocate filed the owner appeal.
His case is for enhancement has to be looked at. Pain recovery ಮಾಡಿದ್ದಾರೆ.
ಮಾಡಿದ್ದಾರೆ, my lord.
What is that? Why the pain recovery?
No permit.
No permit. You have any permit? Then why? What is the purpose of filing an appeal? Why two insurance company?
Same insurance company mala two
ಅಂದ್ರೆ ಒಂದೊಂದು ಕೊಟ್ಟಿದ್ದಾರೆ ಒಳ್ಳೇದಾಗ್ಬಿಟ್ಟು ಇಬ್ರಿಗೂ ಫೀಸ್ ಬರುತ್ತೆ ಅಕಸ್ಮಾತ್ ಒಬ್ಬರೇ ಆಗಿದ್ರೆ ವಾಟ್ ಇಸ್ ದ ಫೀಸ್ ದೇ ವಿಲ್ ಗಿವ್ ಡಿಫರೆಂಟ್ ಆರ್ ಸೇಮ್ ಸಿಂಗಲ್ ಫೀಸ್ yes what is this Mr. 66 that you want to rely on Mr.
Any goods vehicle, the gross vehicle weight of which does not exceed 3,000 kilograms.
ಏನಂತೆ
State.
the holder of the goods carriage permit may use the vehicle for drawing the trailers are not owned by so. Why that exception? The provisions of the subsection shall not apply. The proviso of the subsection 1. The proviso.
Apply. Only the weight 1,725.
What is that, Mr. Patil? What he wants to make? No, you both has to defend. He is saying that pain recovery barala anta, you are liable anta. Necessity of the permit.
Class of vehicle is goods carrier.
Goods vehicle, if the weight doesn't exceed 3,000 kilogram, he said that permit is not required. Then there is no violation of policy condition.
The latent weight of the vehicle now. 3,025.
3,025.
The exceeds not 3,000 kilograms. Therefore, not permit is required.
Yes, Mr. Tell me that. Half a weight of the vehicle. No, date, place, order of the, that is that we are reading. Particular number of the vehicle. Make color, allendri. Akudi or mark ಮಾಡ್ತೀನಿ sir. Unladen weight. Unladen weight registered laden weight seating capacity. Not produced ಅಂತ ಐತೆ ಇಲ್ಲಿ. Exhibit P6 ಅಲ್ಲಿ.
P5 exhibit R5.
ಇದೇನಿದು ಮೋಟಾರ್ ವೆಹಿಕಲ್ ಆಕ್ಸಿಡೆಂಟ್ ರಿಪೋರ್ಟ್ R5. Wait. Weight to 3,225 ಅಂತ ಇದೆಯಲ್ಲ laden weight. Laden weight 1725. Laden weight ಯಾವ ಬೇಸಿಸ್ ಮೇಲೆ ಹೇಳ್ತಾರೆ ನೋಡಿದ್ರೆ ಮಾತ್ರ. Now that this is the laden or unladen weight. Now goods vehicle, the gross vehicle weight of which does not exceeding gross weight ಅಂತ ಹೇಳ್ತಾನಲ್ಲ, what is that?
Latent weight is nothing but not gross vehicle weight. Exceeding not 3,000 kilograms. Therefore, permit is required for this.
Yes.
LGV weight, right?
See, goods which is permitted to carry with a goods, if it is more than 3,000 kilogram, that requires to permit. Your vehicle unladen weight is 1,723. You have been permitted to carry 3,225. Therefore, it requires registration. ಖಾಲಿ ಇದ್ದಿತ್ತಲ್ಲ ಇಲ್ಲಿ ಲ್ಯಾಡ್ ಅನ್ನು ಅನ್ಲ್ಯಾಡ್ ಅನ್ನು ಅಂತ ಹೇಳಿಲ್ಲ ಅಲ್ಲಿ ಪ್ರಾವಿಷನ್ ಅಲ್ಲಿ. Gross vehicle weight of which doesn't exceeding 3 kg. Any goods vehicle, gross vehicle weight, it is unladen ಅಂತ ಹೇಳಿಲ್ಲ ಅವರು. ಅಂತ ಅಂದ್ರೆ ಒಂದೊಂದು ವೆಹಿಕಲ್ ಗೆ ಇಷ್ಟು ಕೆಪಾಸಿಟಿ ಇರ್ತಾರೆ, ಅಷ್ಟೇ ನೀವು ಕ್ಯಾರಿ ಮಾಡಬೇಕು ಅಂತ. ಯಾವ ವೆಹಿಕಲ್ ಗೆ 3,000 ಕಿಲೋಗ್ರಾಮ್ ಗಿಂತ ಕಡಿಮೆ ಕೆಪಾಸಿಟಿ ಕೊಟ್ಟಿರ್ತಾರೋ ಆ ವೆಹಿಕಲ್ need not require permit. That is the meaning. Show me that. Is it that meaning of that provision, Mr. Patil? The holder of the goods carriage permit may use the vehicle for drawing that any trailer, semi-trailer not owned by the subject, the condition as prescribed. The provision of the subsection shall not apply to any transport vehicle owned by the central government, state government. Any transport vehicle used solely for the police for so and so. To any transport vehicle used for towing, transport vehicle used for any other public purpose for any prescribed so and so. To any transport vehicle so and so. To any exceeding.
So, gross vehicle weight is important.
Gross vehicle weight antandre, what is that?
Well, it is interpreted in the Motor Vehicle Act itself. Gross vehicle weight means in respect of any vehicle, the total weight of the vehicle and the certified and load certified and registered by the registering authority as permissible for that vehicle.
Then
15 to 15 well. Interpretation.
No, that laden weight is the total weight of the vehicle.
Laden weight, yes, the gross vehicle weight is prescribed under section 66.
Gross weight antandre total weight of that vehicle
And also certified how much weight it is permissible to carry as per clause 16.
That means no, that permit is given that laden weight is 3,225.
That is not this not coming under this exception. Gross vehicle weight is important, my lord.
I will not find out.
Gross vehicle weight andre enri total weight of the vehicle.
Yes.
Not only total weight of the vehicle, my lord. Interpretation may kindly be seen. Clause 15. Clause 15, my.
Yes.
Means gross vehicle weight means in respect of any vehicle.
And the policy which we have issued for gross vehicle weight is mentioned in policy. That is not disputed.
Where is that?
In policy,
If the gross vehicle weight is less than 3,000, my lord, that is definitely these one because Tata is vehicle not required permit.
See, in the vehicle registration, they have given two weights. One is laden weight, another is unladen weight.
But gross, my lord, the interpretation of laden weight and unladen weight is entirely different. Vehicle.
What is that laden weight meaning?
Laden weight means, my lord.
Is there any definition? Where is that policy, Mr.?
R6.
New act, old act, tell it.
Yes. ನೋಡಿ ಆ ಬುಕ್ಕುದ್ದೇವನ್ ಕೇಸಲ್ಲಿ ಎಲ್ಲ ಎಕ್ಸ್ಪ್ಲೈನ್ ಮಾಡಿದ್ದಾರೆ. You just go through that.
R6. The left-hand side column, ADV not applicable, so and so. One column. Saying CC / G 3,225.
ಏನಾದ್ರು CC
/ GVW gross vehicle weight.
ಅದನ್ನೇ ಇದ್ರಲ್ಲೂ ಹೇಳಿರೋದು. Gross vehicle weight to
Gross vehicle weight is 3,220. Therefore it requires, the official is also examined. Once he admits that there is no.
I am asking.
Yes,
Whatever you have mentioned.
yes.
But in the provision says.
Below
Gross-
3,000 it is not.
Gross vehicle weight of which does not exceed.
Yes,
ಇಲ್ಲಿ ನೀವು ಹೇಳ್ತಾ ಇರೋದು ಗ್ರಾಸ್ ವೆಹಿಕಲ್ weight GVW.
yes,
Yes. Is laden weight is GVW only.
yes.
Laden weight is GVW only. That's what that I said. Unladen weight ಅಂತ ಅಂದ್ರೆ that is that actual weight of the vehicle.
Actual weight.
Yes, this is 3225. That is what that stated in that this thing also.
Yes,
Exhibit,
so permit required, my lord.
Yes, that
Permit.
permit is required. Yes, Mister. Yes. Then next week. That is the only a point. Then his case for enhancement we'll consider. Yes. The request of counsel for the applicant. The respondent. Which respondent, Mister?
Complaint in 422 for I.
Right in yes.
422 for 22.
Serial number ಎಷ್ಟು?
Wednesday.
Yes,
Next
next
Wednesday.
Wednesday.
ಅಲ್ಲ, next Wednesday ಬರ್ತದೆ, ಅದು next.
2 weeks.
Date ಬರ್ತದೆ.
Two weeks ಅಂದ್ರೆ ವೆಡ್ನೆಸ್ಡೇ ಅಲ್ಲ, ಆದ್ರೆ ವೆಡ್ನೆಸ್ಡೇ ಬರುತ್ತೆ. Yes.
The remaining matters, my lord, I have for serial number
But-
49.
230.
230.
230.
My lords, may permit to mention, my lords, serial number 65, a week's time may be granted, my lords. I am for respond number 4. List number 3, serial number 65, my lords.
65. You are respondent.
Respond number 4, my
Request of
lords.
counsel for the respondent. Leave this matter after 2 weeks.
Please, my lords.
Yes, Mr. Senior Counsel. Yes. 40. Seven. Yes. 7. Yes. Huh? 51. Yado serial number 48-7. Serial number 50. 51. 21. Next week.
Next
The
week.
request of counsel for the applicant next week.
Lord, serial
Is
number 54 actually records required, my lord. It is not, it records await.
Yes. Serial number 54. Awaiting PCR. Yes. 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 Learned counsel for the applicant submits that parties have settled the matter in suit. Hence, this appeal will become infructuous. The submission, the memo filed by that learned counsel for the appellant is taken on record. The above appeal is dismissed, having become infructuous. Huh? 50, yes. The request of counsel for appellant, leave this matter next week.
Serial number.
Serial number 44. Yes. At the request of counsel for the respondent, leave this matter next week.
52, my lord. Both are prepared, my lord. Refer to local.
At the request of the parties, refer this matter. Delay of 31 days is condoned.
Yes, ma'am.
Service complete ಆಗಿದೆಯಾ?
ಆಗಿದೆ sir. 62, my lord.
Yes. Refer the matters to local at the request.
Court officer? Court officer? Court officer? Sir, serial number 55 ಏನು ಡೇಟ್ ತಗೊಂಡಿಲ್ವಲ್ಲ? serial number 55.
ಇದೆ ಸರ್.
ಹಾ, ಸರಿ.
ಸರ್ ಓದಕ್ಕೆ ಸಾಹೇಬ್ರ ಮುಂದೆ ಇದಾಗಿದೆ ಅದಕ್ಕೆ ಇದನ್ನು ಮಾಡಿ ಗಮನ ಮಾಡಲಾಗುತ್ತೆ.
ಬರ್ತಾರಲ್ಲ ಅವರು
ಬರ್ತಾರೆ
ಶ್ರೀನಿವಾಸ ಶ್ರೀನಿವಾಸ ಅನ್ಕೋತೀನಿ ಸಪರೇಟ್ ಡೈರೆಕ್ಷನ್ ಇರುತ್ತೆ. ಸಪರೇಟ್ ಆಗಿ ಡೈರೆಕ್ಷನ್ ಇರುತ್ತೆ ಚೇಂಬರ್ ಇಂದ ಯಾವ ತರ ಮಾಡ್ಬೇಕು ಹೇಗ್ ಮಾಡ್ಬೇಕು.
ಡೇಟ್ ಬೇಕಿತ್ತು, ಡೇಟ್ ಬೇಕಿತ್ತು. ಅದು ಇವರು ಸೆಕ್ಯೂರ್ ಮಾಡ್ಲಿಕ್ಕೆ ಲಾಸ್ಟ್ ಡೈರೆಕ್ಷನ್ ಇತ್ತು. ನಂಬರ್ 3 ಅಲ್ಲಿ ಅದ್ರಲ್ಲಿ ಏನಾಗಿದೆ, ಅದರಲ್ಲಿ ಸಬ್ಜೆಕ್ಟ್ ಬೇರೆ ಇದೆ, ನಾಟ್ ಲೈಕ್ ಅದರ್ ಮ್ಯಾಟರ್ಸ್. ಎನ್ವಿ ಪ್ರಾಪರ್ಟಿ ಹ್ಯಾಬಿಟ್ಸ್ ಇದು ಸಿವಿಲ್ಸ್ ಮ್ಯಾಟರ್ ಅಂತ ಆಗಿರ್ಬೇಕು. ಕೇಸ್ ಕನ್ಫ್ಯೂಷನ್ ಇದೆ ಇದು ಅಷ್ಟೇ, ಅದೇ ಕನ್ಫ್ಯೂಷನ್ ಇದೆ.
What is that matter? Tomorrow. Seven. Yes. One. Time. Yes. This is this matter of 2 weeks. Yes, yes, yes. No, I have admitted matter has to be heard. Records is not yet come. Let us see. It will come. When it is come, we can fix the date. We'll no, that matter requires to be hearing in view of that amendment and all. You are not entitled. I have seen that. Let us see. Now it will come. Let the records come. Then we'll. Next time you can fix the date. Yes, we have already signed that order sheet. The afternoon I have signed that order sheet. Otherwise, now I can't recall that. Let us see next time if the date matter is posted, we'll fix that date. Yes. Yes, yes, yes. No, that he has come from that Pakistan passport. No, he came to India after taking the passport of the Pakistan. That means to say he's a citizen of Pakistan. Yes. That is what that they said they will secure that records. He said he will secure the records. Next week, next time you will see. Yes. Yes, 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 yes. After 2 weeks, you can move it later.
But please remember 37, Vijay Kumar, you are correct, and that's been
30?
37.
Yes.
Yeah, Narayan.
Ready?
8 minutes. Case of injury.
Regular. Yes.
2018 data pass date.
2018.
8 minutes.
What is that income?
9,000 as take. Age about 45 years.
500.
8 minutes. 17 days.
17 days.
8 minutes.
Yes. What is that doctor said? Yes.
$10%. 10%.
Why? Total disability as a 60 to the whole body. What is that injury, mister? 20 years. Petitioner as accident, he was sustained injury to his head, neck, stomach, leg, the other part of the body on perusal of the contents of the result of the accident. Question: petitioner has sustained tenderness over the neck and chest, pelvic spine and the whole spine. Speech events of severe signs with due changes, fracture of adjoining vertebral bodies. So what's that 10%? He is a neurosurgeon who has also opined about the disability, intellectual impairment of the patient. Therefore, yes, about disability, intellectual impairment of the petitioner. That's a reliable evidence. Therefore, why it cannot be considered? The neurosurgeon. Injuries to the head. Yes, what is that disability can be assessed? How much? About 20%. Tribunal is 10 20% plus income. Hospital what's conveyances, pain and suffering? Yes. Yeah, that will consider. Towards medical expenses, medical loss of income during the hospital. The medical expenses towards medical expenses put together. Towards loss of future income, amenities is put together. Yes, interest. Yes, that's all.
And disability may be taken on 15% minutes.
Yes, we'll consider. Fine. What so learned council appearing for Climate has contended that due to the accident, Climate has suffered an grievous injury, suffered an head injury. Doctor has been examined as PW2. He has opined that there is a disability. The disability due to the weakness in the limb is 30%, and disability of intellectual impairment is 30%. Total disability is 60% to the whole body. Tribunal has assessed whole body disability is 10% is on lower side. Other contended that at the time of the accident, Climate was earning 200 rupees per day. Tribunal has assessed personal income of the Climate as 9,000
20,000 per month. 20,000 per month.
20,000 per month. Yes. 20,000 per month. The tribunal has assessed 9,000 per month is on lower side. Possibly he has contended that due to the accident, Climate has suffered grievous injury. He was inpatient for a period of 17 days. He has suffered a lot of pain during the treatment. He has suffered with disability and unhappiness throughout his life. Compensation awarded by the tribunal for pain and suffering, loss of abilities, other incidental expenses is on lower side. Hence, is not for enhancement of compensation. For contrast, also learned counsel appearing for this company has contended that even though doctor has assessed disability of 60% to whole body, considering that evidence of doctor and injury suffered by the claimant, the tribunal has rightly assessed whole body disabilities 10%. Even though claimant has claimed that he was earning 20,000 per month, he has not produced any document to establish the same. Therefore, tribunal has rightly assessed notional income of the claimant as 9,000 per month. Other contended that considering that injury suffered by the claimant, considering that medical records and the evidence of doctor, the compensation awarded by the tribunal in suffering, loss of immunities, other incidental expenses are just and reasonable. Hence, he sought for dismissal of the appeal. Or the learned counsel for the parties rules, judgment and award. It is not in dispute. Claimant has suffered an injury in a road traffic accident occurred on 8/3/2018 due to rash and negligent driving of driver of auto bearing registration number AA 54 2664. Even though claimant has claimed due to the accident, claimant has suffered the following injury. Doctor has been examined as PW2. With evidence, he has deposed that claimant has suffered weakness in the limb is 30% and disability of intellectual impairment is 30%. Total disability is 60% to his whole body. Considering that evidence of doctor, considering that medical records produced by the parties, I have the opinion that whole body disabilities can be assessed 20%. Even though claimant has claimed that he was earning 20,000 per month, he has not produced any document to establish the same. Under the circumstances, notional income has to be assessed as per the guidelines issued by Legal Service Authority. For the accident occurred in 2018, notional income has to be considered as 12,500. 18 Alan, right? 12,500. What?
12,500.
Yes. At the time of the accident, he was aged about 45 years. Multiplier applicable to the age group is 14. Accordingly, loss of future earning has been reassessed as follows. Due to the accident, claimant has suffered the aforesaid injury in patient for a period of 17 days. Suffered lot of pain during the treatment. Yet to suffer with disability and unhappiness throughout his life. Considering that the evidence of doctor and injuries suffered by the claimant, can enhance the compensation for pain and suffering from 50,000 to 60,000. Loss of immunities, correct. Loss of income during the later period has to be granted for 4 months. 4 months. Yes. The compensation awarded by the tribunal is just and reasonable. Yes.
Number 38.
Respond.
Yes, ready.
Be ready, my lord. Income, my lord. Tribunal has taken 8,500 per month. 12,500 accident is of year 2018. There are 26 of the judgment.
Yes.
There are 26.
Yes. 2000 disability correct ಮಾಡಿದರಾ?
ಎಲ್ಲ correct.
Yes. ಎಷ್ಟು ದಿನ
parent suffering ಅಲ್ಲಿ
Patient suffering, ಮೂವತ್ತು.
ಸ್ವಲ್ಪ ಜಾಸ್ತಿ.
Because of future income as well. Finance knowledge. Expenses to be like that.
Become during the period of treatment.
Yes.
ಸ್ವಲ್ಪ ಜಾಸ್ತಿ.
Income ಪ್ರಕಾರ ಜಾಸ್ತಿ ಆಗಿದೆ. Amenities ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ? 30 ಕೊಟ್ಟಿದ್ದಾರೆ.
Correct.
Yes. Just 9%.
6%.
That's all. Medical expenses? 69,000 ಕೊಟ್ಟಿದ್ದಾರಲ್ಲ ನೀವು ಕ್ಲೈಮ್ ಮಾಡಿ. ಕ್ಲೈಮ್ ಆದಷ್ಟೇ ಕೊಟ್ಟಿದ್ದಾರಲ್ಲ.
ನಾ ಫ್ಯೂಚರ್ ಜಾಸ್ತಿ ಕೊಡಿ ಅಂತ. ಫ್ಯೂಚರ್ 20 ಕೊಟ್ಟಿದ್ದಾರೆ.
ಫ್ಯೂಚರ್ ಮೆಡಿಕಲ್ ಎಕ್ಸ್ಪೆನ್ಸ್ ಡಾಕ್ಟರ್ ಎಷ್ಟು ಹೇಳಿದ್ದಾರೆ? ಎಲ್ಲಿ ಇದೆಯಾ ಡಾಕ್ಟರ್? ಏನಕ್ಕೆ 30,000? 25 to 30 ಅಂದಿದ್ದಾರೆ, 20 ಕೊಟ್ಟಿದ್ದಾರೆ. ಇನ್ನು 5,000 ಕಡಿಮೆ ಮಾಡಿದ್ದಾರೆ ಅಷ್ಟೇ. Social Learned Council appearing for has contended that time of the accident it was earning 20,000 per month. Criminal has assessed personal income of the claimant as 8,500 per month is on lower side. Secondly, he has contended that due to the accident, the claimant has suffered grievous injury. He was inpatient for a period of 6 days. He has suffered a lot of pain during the treatment. He has suffered with disability and NFNS throughout his life. Compensation awarded by the tribunal, pain and suffering, loss of abilities, other incidental expenses, and future medical expenses are lower in side. Hence, he sought for enhancement of compensation. Contra, D. Vijay Kumar, Learned Council appearing for insurance company, has contended that even though claimant has claimed that he was earning 20,000 per month, he has not produced any document to establish the same. Therefore, tribunal has rightly assessed most income of the claimant as 8,500. Further contended that considering that injury suffered by the claimant, considering that medical records, the compensation awarded by the tribunal for pain and suffering, loss of immunities, other incidental expenses is just and reasonable. Lastly, he has contended that interest awarded by the tribunal 9% is on higher side. Hence, he sought for dismissal of the appeal. Heard the Learned Council for the parties. Arose judgment and award. It's not in dispute. Claimant has suffered an injury in a road traffic accident occurred on 11/5/2018 due to rash and negligent driving of rider of motorcycle bearing registration number KA55L1600. Due to that accident, claimant has suffered the following injury. After considering that evidence of doctor and injury suffered by the claimant, are rightly assessed whole body disabilities 11%. Even though claimant has claimed that he was earning 20,000 per month, he has not produced any document to establish the claim. Under the circumstances, notional income has to be assessed, taking into the consideration of guidelines issued by Karnataka Legal Service Authority. For the accident occurred in 2018, notional income has to be considered as 12,500. The multiplier applicable to that age group is 13. Accordingly, loss of future earning has been reassessed as follows. 12,500 into 12 into 13 into 11%. 14,500. Due to that accident, claimant has suffered the aforesaid injury, inpatient for a period of 6 days. He has suffered a lot of pain during the treatment. He has suffered the disability and unhappiness throughout his life. Considering that evidence of doctor and injury suffered by the claimant, declined to enhance the compensation for claimant suffering from 30,000 to 40,000. Loss of immunities from 30,000 to 40,000. Loss of income during the later period for 3 months. With respect of future medical expenses is concerned, doctor has been examined as PW2. He has deposed that claimant required 25 to 30% for removal of implants. Considering that evidence of doctor, future medical expenses has to be enhanced from 20,000 to 25,000. Will not carry any interest. Enhanced compensation amount carries 6% interest. Accordingly, appeal is allowed in part. Yes, madam. ಅವರೆಲ್ಲ ಇದ್ರಲ್ಲ ಅವರು ವೆರಿ ಸಿ any dispute regarding that liability? Yes, what is the age of the deceased? Password. Yes, yes, ready. Income ಎಷ್ಟು ಮಾಡಿದಾರಮ್ಮ? Right. Yes, 50% has to be taken. That, other 50% has to be taken in view of the division rate. Yes, division rate only. Income ಎಷ್ಟು ಆಗಿದ್ದಾರೆ? Accident date 9,500. 9,500 to 50%. Yes. Social Learned Council appearing for the claimant has contended that at the time of the accident, it was aged about 60 years. But earning 10,000 per month. As considered, notional income of the deceased at 7,000 per month is on lawyer side. Other contended that the claimants are dependents. They are depending upon the income of the deceased. That has not granted any compensation for loss of dependency. Lastly, she has contended that in view of judgment of apex court in case of Magma, the claimants are entitled 40,000 each. Hence, he sought for enhancement of compensation. For contra, Social Learned Council appearing for insurance company has contended that at the time of the accident, this was aged about 60 years. Claimants are major sons. They are not depending upon the income of the deceased. Therefore, tribunal has rightly not granted any compensation or loss of dependency. Secondly, he has contended that even though claimant has claimed that deceased was earning 10,000 per month, they have not produced any document to establish the same. Therefore, tribunal has rightly assessed notional income of the claimant as deceased as 7,000 per month. Considering the age and avocation of the deceased, the overall compensation awarded by the tribunal is just and reasonable. Hence, he sought for dismissal of the appeal. Heard the Learned Council for the parties. Thero's judgment and award is not in dispute. Lakshmamma Edina, Lakshmama died in road traffic accident occurred on 1/5/2016 due to rash and negligent driving of the driver of motorcycle bearing rider of motorcycle bearing registration number K02 JF 3691. Even though claimant has claimed that deceased was earning 10,000 per month, they have not produced any document to establish the same. Other circumstances, considering that age of the deceased, the notional income has to be assessed 3,005 as per the guidance issued by Karnataka Legal Service Authority for the accident occurred in 2016. 9,500 has to be considered. That claimants are the major sons of the deceased. They are not depending upon the income of the deceased. The division bench of this court, considering that the MFA 7318 of 2016 disposed of 23 October 2020 has held that considering the judgment of the apex court and awarded 50% of the deducted 50% of the income of the deceased. Considering that judgment of division bench of this court, the 50% of the income of the deceased has to be deducted for personal expenses. The multiplier applicable to the TH group is 9. Accordingly, loss of dependency has been reassessed as well. Vision, 15,000 for loss of estate, 50,000 for funeral expenses. It's loss of dependency. Entitled for loss of Vision is entitled for 15,000 for funeral expenses, loss of estate. View of judgment of apex court in case of Magma. Yella Maklena. The claimants are entitled 40,000 each. Parental consortium. Yes.
Number 40, number 41, every sitting for opponent is imperative.
Yes. 17. 18 accident.
18.
Yes.
1,000.
Time. 40,000 per month. Disability? Correct. Yes, the hospital libre. ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ ಚಾರ್ಟ್ ಇಲ್ವಾ suffering 30,000 loss of immunities ಅದೇ immunities loss of future income ಆಯ್ತು medical expenses ಕೊಟ್ಟಿದ್ದಾರೆ food and nourishment later period immunities ಅಂತಂದ್ರೆ ಅದೇ loss of expectation of life ಅಲ್ಲಿ immunities ಎಷ್ಟು ದಿನ ಹಾಸ್ಪಿಟಲ್ ಇದ್ರೆ 4 days ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ
Only income has to be.
so and so learned counsel appearing for claimant has contended that at the time of accident, he was earning 40,000 per month. Tribunal has assessed notional income of the claimant as 10,000 per month is on lower side. He further contended that due to that accident, claimant has suffered grievous injury. He was inpatient for a period of 4 days. He has suffered lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. Compensation awarded by the tribunal for pain and suffering, loss of immunities, other incidental expenses is on lower side. Hence, he sought for enhancement of compensation. Contra, the ready learned counsel appearing for insurance company has contended that even though claimant has claimed that he was earning 40,000 per month, he has not produced any document to establish the same. Therefore, tribunal has rightly assessed notional income of the claimant as 10,000 per month. He further contended that considering that evidence of doctor and injury suffered by the claimant and medical records, the compensation awarded by the tribunal for pain and suffering, loss of immunities, or incidental expenses are just and reasonable. Hence, he sought for dismissal of the appeal. Or the learned counsel for the parties. The judgment and award is not in dispute. Claimant has suffered an injury in a road traffic accident occurred on 30/7/2018 due to rash and negligent driving of driver of motorcycle bearing registration number AA44U3225. Due to that accident, claimant has suffered the following injury. Considering that evidence of doctor and injury suffered by the claimant, tribunal has rightly assessed whole body disabilities 10%. Even though claimant has claimed that he was earning 40,000 per month, no document has been produced. Notional income has to be assessed as per the guidelines 12,500. The multiplier applicable to the age group is 18. Accordingly, loss of dependency has been reassessed as follows. As his age is 65 years, multiplier is 18 and 23 years.
Correction ಮಾಡಿಲ್ಲ.
Yes. Yes. Due to that accident, claimant has suffered the aforesaid injury. He was inpatient for a period of 4 days. He has suffered a lot of pain during the treatment. He has suffered this disability and unhappiness throughout his life. Considering that evidence of doctor and injury suffered by the claimant, I mean, trying to enhance the compensation for pain and suffering from 30,000 to 40,000, loss of expectation of life and loss of immunities from 20,000 to 40,000. Loss of income, the claimant is entitled for loss of income during the later period for 2 months. Compensation awarded by the tribunal in the other hand are just and reasonable. Yes. Yes. Hmm.
42%
42% and
42% right.
hmm,
Left lower limb 38%.
38%.
Lower body disability 26%.
By the doctor.
Please.
Criminal ಎಷ್ಟು ಮಾಡಿದಾರೆ?
18%.
Why? 42% left lower limb. ಇನ್ನು 38% right lower limb. ಎರಡು lower limb. 42 plus 38 ಎಷ್ಟಾಯ್ತು? Divided by 3 ಆದ್ರೆ 26.6. Income?
Income 12,000 rupees.
14,000.
Criminal ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ?
12,000 rupees.
12,000 ತಗೊಂಡಿದ್ದಾರೆ. 2019
19. 14,000.
ಎಷ್ಟು?
20,000.
ಎಷ್ಟು ದಿನ ಹಾಸ್ಪಿಟಲ್ ಅಲ್ಲಿ?
7%.
Loss of immunities. Income during the later period. ಎಷ್ಟು ದಿನ ಐತ್ರಿ? 6 days.
7 days.
Yes. Yes, second. So learned council appearing for Senate has contended that to the extent Senate has suffered grievous injury. Doctor has been examined as PW2. In his evidence, he has proposed that claimant has suffered 42% disability to left lower limb and 38% to the right lower limb. All body disabilities 26%. There are assessed all body disabilities 18% is on lower side. Secondly, he has contended that at the time of the accident, claimant was earning 20,000 per month. Criminal has assessed notional income of the claimant as 12,000 per month is on lower side. Thirdly, he has contended that due to that accident, claimant has suffered grievous injury, was inpatient for a period of 6 days. He has suffered lot of pain during the treatment. He has suffered with disability and unhappiness throughout his life. Compensation awarded by the tribunal for pain and suffering, loss of immunities, other incidental expenses is on lower side. Hence, he sought for enhancement of compensation. Tata, the Mallikarjun Reddy Learned Council appearing for insurance company has contended that even though doctor has deposed that claimant has suffered 25%, 26% disability to whole body, considering that evidence of doctor medical records and considering that age and avocation of the claimant, the tribunal has rightly assessed whole body disabilities 18%. Even though claimant has claimed that he was earning 1,000 per month, he has not produced any document to establish the same. Therefore, tribunal has rightly assessed notional income of the claimant as 12,000 per month. Thirdly, he has contended that considering that injury suffered by the claimant and considering that evidence of doctor and medical records, compensation awarded by the tribunal, pain, loss of immunities, other incidental expenses is just and reasonable. The interest awarded by the tribunal 7% is on higher side. Hence, it is sought for dismissal of the appeal. Or the learned counsel for the parties. Errors, judgment and award. It is not in dispute. Claimant has suffered an injury in the road traffic accident occurred on 26/2/2016 due to rash and negligent driving of driver of car bearing registration number KA 53 MF 1009. Due to that accident, claimant has suffered the following injury. Doctor has been examined as PW2. In his evidence, he has deposed that claimant has suffered 42% disability to left lower limb, 38% to the whole body, 38% to right lower limb, and 26% to whole body. Considering that evidence of doctor and considering that age and avocation of the claimant, I am of the opinion that whole body disability is assessed 26%. Even though claimant has claimed that he was earning 20,000 per month, he has not produced any document to establish the same. The circumstances, notional income has to be assessed as per the guidelines. For the accident occurred in 2019, notional income has to be considered as 14,000. The time of the accident, he was aged about 3 years. The multiplier is 9. The future loss of income is assessed as 14,000 due to the accident, claimant has suffered the aforesaid injury. He was inpatient for a period of 6 days, suffered lot of pain during the treatment. He has suffered this disability and uneveness throughout his life. Considering that evidence of doctor and medical records, I incline to enhance the compensation for pain and suffering from 30,000 to 40,000. Loss of income, loss of immunities from 25,000 to 40,000. Loss of income during the later period has to be granted for 2 months. Compensation awarded by the tribunal in the other hand are just and reasonable. Next compensation amount is 6% interest. Number 43 Decoder, number 44 Advent, number 45 Mahadeva Swami people applied, ಏನ್ ಡಿಸ್ಪ್ಯೂಟ್ ಇಲ್ಲಲ್ಲ ಎಲ್ಲಿದೆ income of the disease said to be 40,000 per month. He was working as a lab tech. Mastery diagnostic. Petitioner got examined GTS Ramesh. It is salary slip test is there. There is a difference every month salary, but gross salary is 15,332. ಎತ್ತಿತ್ತು 15 ಹೆಚ್ಚಾರಿಗೆ 5 last salary 26,000 ಬಂದಿ ಅದು ಸಂಡೇ ಅಲಯನ್ಸಸ್ ಎಕ್ಸ್ಟ್ರಾ ಡಿಟಿ ವಾಟ್ ಅಬೌಟ್ ದಟ್ ಅದರ್ ಮಂತ್ಸ್ ಮಾರ್ಕ್ಸ್ ಎಷ್ಟಿದಾವೆ ಎಲ್ಲಾ ತಿಂಗಳಲ್ಲೂ 36 ಇದೆಯಾ ಲಾಸ್ಟ್ ಇಯರ್ ಅಲ್ಲಿ 26,000 ಏನ್ ಲಾಸ್ಟ್ ಇಯರ್ ಅಲ್ಲಿ 26,000 ಸಂಡೇ ಅಂಡ್ ಎಕ್ಸ್ಟ್ರಾ ಎಲ್ಲ ಸೇರ್ಬಿಟ್ಟ ಅದೇನಿದೆ ಲಾಸ್ಟ್ ಇಯರ್ Bank statement ಅಲ್ಲಿ 26 last year ಯಾಕೆ ಅಂತ. No, 36,000 ನಿಮಗೆ ಆಯತಿಗೆ ಕೊಡ್ತಾ ಇದ್ದಿದ್ದು ಕರೆಕ್ಟ್. ಬಟ್ ಈಸ್ ಇಟ್ ದ ಸ್ಯಾಲರಿ ಫಾರ್ ಎಂಟೈರ್ ಲೈಫ್ ಟೈಮ್? ಎಲ್ಲಿದೆ ಇಯರ್ಲಿ ಎನ್ಹಾನ್ಸ್ಗೆ ಫ್ಯೂಚರ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ ಬರುತ್ತಪ್ಪ. ಸ್ಯಾಲ್ರಿ 30 ಈಗ 26,000
November 34,584. December 33,787.
ಸ್ಯಾಲ್ರಿ ಇದೆಯಲ್ಲ 26,215 ಗ್ರಾಸ್ ಸ್ಯಾಲ್ರಿ. ದಟ್ ಈಸ್ ಕರೆಕ್ಟ್. ದಟ್ ಕೆನಾಟ್ ಬಿ PF ಎಂಪ್ಲಾಯೀಸ್ ಇನ್ಶೂರೆನ್ಸ್. ಗ್ರಾಸ್ ಸ್ಯಾಲ್ರಿನೇ ತಗೊಳ್ಬೇಕು ಅಷ್ಟೇ ರೀ, ಬೇಸಿಕ್ ಅಲ್ಲ. ಗ್ರಾಸ್ ಸ್ಯಾಲ್ರಿ ಅಷ್ಟು ಕನ್ಸಿಡರ್ ಅಷ್ಟೇ. ಗ್ರಾಸ್ ಸ್ಯಾಲ್ರಿಲಿ ನಿಮ್ದು ಡಿಡಕ್ಷನ್ ಅನ್ನ 2 ಡಿಡಕ್ಷನ್ಸ್. ಎರಡು ಇದಾವಲ್ಲ, ಈ ಬೋನಸ್. ದಿಸ್ ಇಸ್ ನಾಟ್ ಯುವರ್ ಸ್ಯಾಲ್ರಿ. ಎಕ್ಸ್ಟ್ರಾ ಡ್ಯೂಟಿ ಮಾಡಿದ್ರೆ ಮಾತ್ರ ಕೊಡ್ತಾರೆ. ಸಂಡೇ ಅಲವೆನ್ಸಸ್. ದಟ್ ಡಸಂಟ್ ಮೀನ್ ದಟ್ that will be you will do that Sunday allowance every till your death, mister. ಎರಡೇ ಇರೋದು, ಒಂದು ಬೇಸಿಕ್, ಒಂದು ಗ್ರಾಸ್. ಬೇಸಿಕ್ ತಗೊಳ್ಬೇಡಿ ಅಂತ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ. ಗ್ರಾಸ್ ತಗೊಳ್ಳಿ. ಆಲ್ ಅಲವೆನ್ಸಸ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಕನ್ಸಿಡರ್. ಗ್ರಾಸ್ ಅಲ್ಲಿ ಓನ್ಲಿ ಪ್ರೊಫೆಷನಲ್ ಟ್ಯಾಕ್ಸ್, ಇನ್ಕಮ್ ಟ್ಯಾಕ್ಸ್ ಇದ್ರೆ ಡಿಡಕ್ಟ್ ಮಾಡಿ ಅಂತ ಅಷ್ಟೇ, ಎರಡೇ. ಇದು ಎಕ್ಸ್ಟ್ರಾ ಡ್ಯೂಟಿ ಮಾಡಿರೋದಲ್ಲ. ಅದ್ ಯಾವಾಗ ಡ್ಯೂಟಿ ಮಾಡ್ತೀರೋ ಅವಾಗ ಕೊಡ್ತೀರಾ. ಇಟ್ ಇಸ್ ನಾಟ್ ಯುವರ್ ಸ್ಯಾಲರಿ ಟು ಎಂಟೈರ್ ಯುವರ್ ಲೈಫ್. ನೆಕ್ಸ್ಟ್ ಮಂತ್ ನಾನು ಎಕ್ಸ್ಟ್ರಾ ಡ್ಯೂಟಿ ಮಾಡಲ್ಲ ಅಂತೀರಾ ನೀವು. ಎಂಪ್ಲಾಯೀಸ್ ಕೆನಾಟ್ ಕಂಪೆಲ್, ಬಟ್ ಹಿ ಹ್ಯಾಸ್ ಟು ಪೇ ದಟ್ ಸ್ಯಾಲರಿ. ದಟ್ ಈಸ್ ಹೌ ದಟ್. ಕೆಲವರಲ್ಲಿ ಬರೀ ಬೇಸಿಕ್ ಮೇಲೆ ಡಿಸೈಡ್ ಮಾಡ್ತಾರೆ. ದಟ್ ಈಸ್ ರಾಂಗ್. ನಿಮ್ದು ಬೇಸಿಕ್ 15,000 ಇದೆ. HRA ಅದರ್ ಅಲವೆನ್ಸಸ್ ಹ್ಯಾಸ್ ಟು ಬಿ, then it shows gross. Grass has been considered by the tribunal rightly. 26,000 as rightly considered. ಅದು ನೆಟ್ ಸ್ಯಾಲ್ರಿ ನಿಮ್ದು 36,332 ಗ್ರಾಸ್. ಅದನ್ನ ಸೇರ್ಕೊಂಡು ಎಕ್ಸ್ಟ್ರಾ ಡ್ಯೂಟಿ, Sunday allowances. Sunday allowances, ಸಂಡೇ ವರ್ಕ್ ಮಾಡಿರೋದು ನಿಮಗೆ ಕೊಡ್ತಾರೆ ಅಷ್ಟೇ. ನೀವು ವರ್ಕ್ ಮಾಡಿದ್ರೆ ಮಾತ್ರ. ಇಟ್ ಇಸ್ ನಾಟ್ ಪರ್ಮನೆಂಟ್. ನೀವು ಕೆಲಸ ಮಾಡ್ತಾ ಇದ್ರೆ, ಸಂಡೇ ಕೆಲಸ ಇದ್ರೆ ಮಾತ್ರ ದುಡ್ಡು ಬರುತ್ತೆ. ಅಕಸ್ಮಾತ್ ನೀವೇನಾದ್ರು ಇದ್ದು ಸಂಡೇ ಕೆಲಸ ಇದ್ದಿದ್ರು ಆ ದುಡ್ಡು ಬರೋದಿಲ್ಲ. ನಾವು ದಟ್ ದೇ ಕಾಂಟ್ ಗಿವ್ ದಟ್. But you have to consider that what is your salary, that's all. ಇದೆ ಫ್ಯೂಚರ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ? Show me that additional amount which is given, considered as this thing, any judgment on that. Judgment, you give that judgment, any judgment on that point. All that is only a gross and net salary. Yes. Request of counsel for leave this matter next week. Yes. ಎಲ್ಲಿದ್ದಾರೆ ನಿಮ್ಮ ಅಪೋನೆಂಟ್? ರೆಕಾರ್ಡ್ಸ್ ಬೇಕಾ? ಆಯ್ತು, ನಾನ್ ರೀಸನ್ ಕೊಡ್ಬೇಕಲ್ಲ, ನಾನ್ ಕೊಡಕ್ ರೆಕಾರ್ಡ್ ಮಾಡ್ಬೇಕು ತಾನೆ. ಅವ್ರು ಕೊಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ I will secure. Anyhow, your friend is not there. Yes, office is directed to secure original records. What immediately after records, the receipt of records.
Number 47, friend, Manjunatha Reddy.
Yes, Mr. Gowda, who is your opponent? What is this? Now, what is that order you are challenging? Anybody claiming under them restraint from interfering with the plaintiff peaceful management. As you maintain status quo. Peaceful police and enjoyment over the scheduled property by blocking the obstruction of the road pending disposal of the above suit. ಎಲ್ಲಿದೆ ರೋಡ್? Are you blocking any road? That the use of degree permanent injunction restraining the defendant from putting up any construction or gate between the road in order to block the use of the zone. So, what is heading the last one? For residents in RCC building. Yes. He is your opponent, Manjunath Reddy. Yes. What the learned counsel for the opponent? Stay up. Updated. So and so till next date appearing.
48 and then.
See, 49, I am for respondent, my lord. It's a
Yes, other matters will take next week.
49 only, 49. See number
No,
49, very small submission. My lord, this it is an insurance company appeal, my lord. It is actually it is a dismiss for default against the owner of the vehicle in the year 2019, my lord. I filed an IA for permitted to withdraw the appeal, the amount deposited by the insurance company. My lord, there are several times, my lord, opportunity was given, but no steps was taken. Most probably insurance company has no interest to prosecute the matter.
Because now it is posted for hearing, Mr.
Owner of the vehicle, this is dismissed. My lord, my kindly see the cause list. So appeal does not survive. Their contention is against the vehicle is not involved. The 3 days delay. So steps to R1 is presence of owner of the vehicle is very much necessary. But since they are not taking the steps, my lord, with pressure, my lord, I have lot of pressure to permit me to. Several occasions it was posted.
You want any date? No, because 3 times I have to go for a meeting. I have an interview for last 1 month. I have to. Yes. Another 2 weeks is there. Now that any date you want.
Next week, yaವಾಗ shortest date, ma'am, because I want to pressing into service that IA, ma'am.
Last one matter, list number 3, serial number 18. P. Ravisankar for appointment, connected matter.
Internally, I have filed application for seeking withdrawal of. Yes,
Appear for the appellant. Even when the matter is called in the morning session, even when the matter is called afternoon session, none appear for the appellant. Counsel for the respondent is present. As a last chance, release this matter on next Wednesday. If they are not come, then I will consider your application.
Hey, my request on 29th,
29th Wednesday.
Please, Malad, there is one more connected matter. MFA 8246 of 2020 arising out of the same accident.
Yes.
Same set of facts.
Call this matter along with it soon.
MFA 8246 of 2020.
Yes. ಬೆಳಿಗ್ಗೆ ಅರ್ಜೆಂಟ್ ಆಗಿದೆಯಲ್ಲ ಔಟ್ ಆಗಿರೋದು ಏನು 56, 51, 58, 51. Not rated, please next week.